Chairperson, I think what I said was that firstly, I did not acquire any legal opinion on this matter. And the reason why I did not acquire any legal opinion is because there was existing practice in terms of the appointment of chief executive officers of SETAs. And thirdly, and which I think is even more important, is that the Act itself and the regulations are very clear in terms of their stipulation on what the role of the minister is and what the role of the accounting authority is. And lastly, even if what you confirm as legal opinion and what Advocate Kuta has confirmed as legal opinion, I have not acted inconsistent of that legal opinion. Advocate Kuta is Chief Director of Legal Affairs. She will, of course, have a legal opinion on any matter that relates to the law in our department. And I think the point is that even if the legal opinion existed, and even if that's what the legal opinion said, I did not act outside of what is required of that legal opinion.
Chair, I put it to the minister that that is not true. Let's start here. Let's go to Mekuta. Mekuta, who gave you the instruction to compile a legal opinion within the department around these appointments?
The request came from Mr. Ngubane.
Mabuza Ngubane.
Yes.
Where's Mabuza Ngubane is not here today. And his boss would be you, Dr. Mabusela. Welcome to the team while we're still waiting for 1.3 million. So what happened, Dr. Mabusela?
Thank you very much, Honorable Kakao.
Your microphone, Dad.
Oh. Yeah, thank you very much, Honorable Kakao and Chair. There are processes within the department, and the one, not even one, branches that are missing in this whole thing is the skills branch that you are now raising, and also the
you
NSA.
are the skills branch.
Yes,
You are
yes,
here.
I'm coming to that.
Yeah.
Those are the branches that are also involved in this. Now, a chief director cannot proceed with a submission to the level of the minister.
Without
If-
the Director General.
Yes, without the director general or acting director general for that matter having approved that.
I hear you and I know that, but I'm asking to you, Hore, how did we get here? Because there's no way, like for me, I'm not convinced at all because the compilation date of this thing was on the 1st of October. The document I'm referring to that the minister claims he knows nothing about, which is an actual file reference 17/4, which serves as a submission to his office. There's no way. Even his PAs cannot deny to not have had this. But that's fine. Even if you say you don't know it, and you're saying you are acting inconsistent, you did not act in inconsistency with it. The bottom line is you must then explain to the Republic of South Africa why you proceeded to appoint Yeshin Pillay, Ayanda, Mafulega, Dr. Phil Yende, Ms. Gugum Kize, Mr. Matume Madibana, Mr. Thabo Mashongwane, Mr. Tom Mkwanazi, as CEOs after, even though your legal department is of the opinion, I want to read again, that the minister, that they may not be recommended or appointed as acting CEOs or anything upon expiry of the contracts because they're no longer employees of SETA come 30 September. So because outgoing CEOs cannot be regarded as employees beyond 30 September 2025 and therefore cannot be recommended in that capacity. And most importantly, any recommendation that includes outgoing CEOs for acting positions should be regarded as irregular. So I'm saying to you, you can, with me, argue to say, number one. Number two, that you didn't act. But the bottom line is that Mekuta, gave your department this legal review during the process of your appointments? Mekuta?
Thank you, Chair.
Can I Mekuta first? Yeah.
Yeah. I think, Mayor, how the issue here is, what does the AA has to do come 30 September? And according to the Act, if on the 30th of September, the incumbent CEOs were recommended by their respective accounting authorities to the department, the Act does not define what happens once the recommendation gets to the department in terms of how long does the minister have to process these recommendations and how much time does he need. Hence, we say in law, it has to be reasonable time, it has to be lawful, and it has to be ethical, and it has to be within the usual reasonableness that you'd expect from a decision maker. A decision maker cannot sit on recommendations that he has received on time. And according to the office of the minister, they received all of these recommendations on the 30th of September, meaning that these CEOs were still within the system. However, minister only worked on the recommendation beyond the 30th. The issue is, when were the CEOs still within the system?
Your
Yes.
words say, because now we are playing legal.
No,
meando.
not at all, ma'am.
Nkudla, hear me.
No.
Also indulge me, and you can correct me if I'm
Okay.
wrong. I don't mind you doing that.
Yes.
You are saying, hore, your words in your opinion say, hore, outgoing CEOs cannot be regarded employees beyond 30 September, and therefore cannot be recommended. Because come 30 September, when you on the 1st of October wake up at midnight, those people will not be employees. The only way you become an employee again beyond the 30th of September is if you have an appointment letter that would have had to be signed and delivered by the minister. 'Cause that's what your legal opinion is saying. So you're saying you cease to have, you cease to become a member on the 30th of September, but then you have time between the 1st and maybe the 25th of November to be a member. Why would the inconsistency in thought there?
I hear your point, ma'am, and I must say, the issue here is, when did the AA recommend?
I'm not, okay, I would your point. So
Yes.
recommendation serves as null and void up until appointment is made. So,
No, no,
a recommendation
I do
is,
not-
so my
I do not
membership,
agree.
my employment ceases to exist on the 30th of September. That's what your observation is in law. That is true. If my appointment expires, but there's a recommendation, come between the 1st of October and the date of the submission of my appointment, reappointment, or extension of my service, I remain unemployed. It's not that I'm in the system, because on the 30th, my membership or my employment would have expired. And that's the bone of contention here, Mekuta.
Honorable member, the AA, when did they give the recommendation of the CEOs?
On the 30th.
On the 30th.
And when did the minister appoint? In varying times up until the 19th. So you and I
Yes.
are together. I'm not questioning, we are together. We agree that recommendations were made. Recommendations are not
Made on
appointments, they are recommendations.
I don't want to lose this point.
Yes. Recommendations were made on time.
That is not what you,
Yes. And the minister,
I hope, Chair,
Okay,
20 minutes
that's
efedile, so, but the point here is there's an irregularity. You can't confuse an appointment and a recommendation. Those are two different things. A recommendation is something, and to show you that they are not the same thing, you even submit 3 names for the minister to to consider himself, that if he doesn't want one, he can choose the other. So it's not a set in stone thing altogether. The word recommendation even in English itself is not an appointment. So you can't argue that because the recommendation came on the 30th, but the appointment did not come on the 30th, that there's nothing wrong going on there. So the point I'm making here is what has fallen to become a problem here is the classic case of maladministration on the basis of just comprehension of appointment and recommendation. And I hold no legal degree, but common sense prevails that there's a difference between recommendation and appointment. I'll close it there. There's 3 other things, but we'll give another round. Thank you.
Thank you. Just to,
Hold on.
oh,
The Mabusela, what's wrong with your mic? It keeps being on.
Oh, Chair, I just wanted to ask, that is a point of exigency allowed?
So you were pressing the mic. Okay, maybe.
thank you. Chairperson, I think our recourse here, Honorable Member, doesn't have to be common sense. I think it has to be the law. And in this case, the law instructs the accounting authority to make a recommendation for appointment before the contract of the person being recommended expires. That's the obligation that the Act imposes on the accounting authority. I think that point is important. And as to when the concurrence from the minister happens, there is no specificity either in the Act or in the regulations as to what is the time bound required. And so I do not agree. The honourable member has put it to me that I've broken requirements of the Act. Thank you.
Honorable Lanzo, what is the point?
Chair, yeah, just a quick point here. Firstly, I don't agree with what legal and the minister is saying. But I want to expose something here, even their own version, because legal is arguing that a recommendation must be made before the 30th of September. That's their argument. And then she's saying it doesn't matter when the minister makes the appointment. I don't agree with that. But I'm saying even their own version doesn't stand. Why? By the 30th of September, the accounting authorities did not make the recommendation that the minister sought. How do we know this? On the 6th of October, the minister writes a letter to the accounting authority and says, it has come to my attention that you guys didn't do what I asked for on the 29th of September. Therefore, I am giving you until the Friday, the 10th of October, to make a recommendation to the minister. Now, I'll put it to legal. If a recommendation, since you've been steadfast on this view that a recommendation must be made by the 30th of September, if a recommendation is made after the 30th of September, on the 10th of October, is that lawful?
that is not lawful. No, I need to explain.
No, that's all I wanted to hear.
No.
I'm still coming. I was just clarifying this point.
I don't think it is fair that you don't allow me to explain.
Okay,
Yes.
sorry, you can explain.
Yes. You are referring to a letter that you say minister wrote explaining himself to say there seems to have been a misunderstanding in terms of what I expected the AA to have done come 30th of September. And what I have received as the minister does not address what I expected on the 30th of September. And therefore, please go back to the drawing board and give me what I expected from you. And that only happens after minister is going through what has been submitted on the 30th of September. And him only writing to them on the 6th, as you correctly pointed out, is when he is going through what is on his table to say, this is what I expected, and what I have received is not what I asked for. And therefore, made understanding in my communication to the
Compliant.
Let's give a chance to finish.
Okay. All that I'm saying, honorable members, is that come 30th September, AAs did what they did. And it is only when minister goes through what has been submitted to him that he realizes that this is not what I had asked for. I had asked, according to Section 13B1 of the Skills Development Act, that 3 names would be given to me to say we do not recommend the incumbent CEO to continue working with us. And the Act talks about further appointment. Where the AA does not recommend a further appointment, they will then have to recommend from the 3 or 4 executives that are within that SETA to then be appointed to act.
Okay,
And minister,
so let's do this, advocate.
yeah,
So you're saying to us, after the letter of the 6th by the minister, there were no meetings that set to correct the mishappenings of the meetings of the 30th.
I would imagine that there would have been meetings to correct what was wrongly submitted on the 30th.
Yeah, so then what is the status of those meetings? The continuation of the meeting of the 30th?
I would want to agree with you, Chair, that it's a continuation of the meeting of the 30th. It can't be a new meeting altogether.
And the submission now is corrected. So when it's sent, when it is now made in the correct context where the minister would have asked the correct steps to be taken, it does not nullify the submission of the 30th or the recommendations of the 30th.
I'll allow Minister to answer for himself. Thank you.
Minister?
Thank you, Chair, because I wrote the letters and I'm here. I think that that's important to mention.
Yeah, we're asking because you had
Yes.
said to Honorable Kakao,
Yeah.
we're not lawyers, we're lawmakers. So wanted to understand from a lawyer point of view.
Yes. What I think it's important, because what Honorable Lonzi is raising should also be understood, I think, within that within that context. And let me give you an example, and this is what actually happened. So in the case of one of the SETAs, they made recommendations of 3 names, and one of those names for acting, and one of those names was the incumbent CEO, and it was clear that the SETA did not understand. They had an intention to comply with legislation and with regulations and in my directive, but that in having that intention to comply actually did not, because they would not have recommended an incumbent CEO for a new appointment. And I think subsequent to us asking them to correct their ways, they came back with a recommendation, which was basically that we should appoint that particular CEO. This is precisely because the intention and spirit of the accounting authority was to comply with the directive as we issued. But in executing that directive, it was clear that there was a confusion. And that's why I wrote further to them to say that I think it's important that you understand what the directive was and comply with that, with that continuation. But I think it's also important that we emphasize that, and I cannot emphasize this anymore, and it would probably be a subject of interpretation. But the fact that the obligation is on the accounting authority to make a recommendation at the time when the contract is active. As to what happens thereafter, it's something else. I, am not doubtful of the genuineness of the accounting authorities in making the recommendations that they have made. Thank you.
Honorable Khabo.
No, thank you very much, Chairperson. Thanks for the opportunity. Maybe let's appreciate the effort by the Minister in terms of taking us into confidence on the process that he had followed. And also appreciate the fact that everything, according to the explanation, has been done according to what the current Act says. And if, unfortunately, if the Act is silent on certain issues, especially on and around the turnaround time of the Minister and the process that he needs to follow, when the Act is not clear from one sitting chairperson, we would then be embarking on a fishing expedition, of which to a large extent would be reliant on our emotions and our common sense, without speaking to what the law says as things stands. Maybe what we must argue as a portfolio is on and around the legislative gaps that we have identified on how we should work on them, so that moving forward we should not sit here and discuss our suspicion on what the law says compared to what the real people who are legal gurus in this context, the legal opinion, clarifying on what the legal aspect of the law says. I think that one, it's important that we must appreciate, Minister, because the impression sometimes that has been created is that we don't want to take responsibility of your actions, and in those instances, we then create a vacuum for misinterpretation of facts. So it is for that reason that I appreciate your presence. But maybe going back to some of the issues that I had wanted clarity on our meeting with, my apology, Chairperson. Our meeting of the 26th of October, if not mistaken, and while we are interacting with the two SETAs, mere SETA and construction SETA in particular, the DDG took us into confidence in terms of the process that you had followed. Because my question, when we're meeting construction SETA and mere SETA,
It was on the 29th of October.
29th of October. Now, the DDG at that time who was acting, Ntate Mabizela, if not mistaken,
Mabusela.
Mabusela.
That the Mabusela. Stop opening our mic. Sure.
Now, I posed the question to Ntate Mabusela. I posed the question to Ntate Mabusela during that meeting. And my question was that when we were placing the 3 SETAs under administration, referring to the 3 ones that are under administration, was there assessment conducted on all the 21 SETAs to verify the dysfunctionality of governance as it has been indicated or it has been presented? Mr. Mabusela made or raised the view that in a normal circumstance, the minister will then make that assessment of the 21 SETAs before taking any decision of placing a SETA under administration. And my understanding was that an assessment was done. Now, my question to him was that whether the assessment was conducted on all other 21 SETAs, including the 3 ones that you have placed under administration. And I would want to check with you as to those assessment of dysfunctionality. Was it only on the 3 ones that were placed under administration, or the assessment covered all the 21 SETAs?
Okay. I think sometime earlier in the year, Honorable Member, the minister led, then Minister Nkabani led a delegation to this portfolio committee to present the report on the 5-year assessment of the performance of all the SETAs. In fact, I think it was at the request, if I'm not mistaken, of this portfolio committee. And at the time, the recommendations from that report, conducted by the National Skills Authority, was then used by the then minister to, not only start the process for the appointment of new accounting authorities and chairs and CEOs, but also to make an assessment of what needs to be done to reform the SETAs. That report has also informed our work subsequently in the reference group that we've put in place to look into the, into the SETA reforms. But to also be a bit specific, upon assuming office, I received a report from the National Skills Authority, which also touched on some of the performances, particularly issues almost relating to misconduct from the National Skills Authority. And it was their assessment in the overall of all the SETAs or the SETAs which they deemed to have had challenges. I've since copied, I think, the chair, that report, which I hope has been sent to the honorable members. If it has not been copied to the chair, I think we can arrange that the CEO of the National Skills Authority furnishes members with that report if the report is allowed to be made public. Thank you.
No, thank you very much, Minister. In terms of that report, let alone the one that was commissioned by the previous minister, let's talk of the report that you speak of that came from NSA. Was the assessment, like I said, the first question was whether the assessment was done on the 21 SETAs. The second question would be the governance dysfunctionality. Was it only on the 3 SETAs that were placed under administration?
No, it was.
Minister, you know, I'm not from Limpopo.
it was
I can't
not-
interpret your
It was
prophetic
not,
actions.
It was not. I said no, it was not just on the 3 SETAs, but it was overall in the assessment of the performance of all the SETAs on all those areas that they've mentioned.
So maybe if you can take us into confidence, apart from the 3, which other 3 SETAs were highlighted, and why did the minister not act on other SETAs?
I don't have the report now, unfortunately.
So would you agree with me that as per the report that was presented before us indicating dysfunctionality on the 3 SETAs, would you agree with me that one of those challenges of financial mismanagement and maladministration is not only happening on the 3 SETAs that we have placed under administration? Would you agree with me?
Well, I don't have the report, honorable member, so I cannot agree or disagree with you.
Let alone the report, Minister, on your observation and interaction with the SETAs.
Yeah. So, for instance, if I were to use the Auditor General, yeah. So, for instance, if I were to use the Auditor General, Auditor General's report from the previous assessment, if we're talking about financial performance of SETAs, I don't have the specific names of the SETAs. I just have a summary that 13 of the SETAs in the 24-25 report achieved clean audits. 6 achieved unqualified audits with findings, and 2 SETAs received qualified audits.
Maybe we must agree that, Minister, because of you spoke of the report, and the report clearly indicates which other SETAs. And maybe you must submit a written response
Yes.
on why did you disregard others, even though they were clearing signs of dysfunctionality and mismanagement of funds. I think we can leave it there on the other ones that you did not place
Can
under
I-
administration.
Can I ask which report, which SETAs would you want me to specifically respond to? And why you're asking me why I didn't put them under administration, and then I can respond specifically
Yes.
to those.
Out of the
If there are
21
reasons.
sitters,
Yeah.
we were told that you have conducted an assessment on all of them.
Yes.
And part of the report that we have received from the Auditor General indicates other sitters, apart from the 3 that you have placed under administration. It is for that reason I'm requesting you a written response as to why did you disregard other sitters, even though they are having same signs of dysfunctionality, maladministration, mismanagement of funds.
Yeah.
In line with the Auditor General's outcome. Hence, I'm saying that rather you can submit a written response because obviously their reasons are not the same.
No, but I must indicate that the question of the Auditor General's report 2024-2025 is not the basis which we use to put SETAs under administration. Actually, if any institution is put under administration on the basis of of the Auditor General's report, then I think there would be serious, if that's the only determination on why an institution must be put in under administration. But what I must also emphasize is that I think of the SETAs that were found to have financial challenges, 2 of the 3 SETAs are actually the ones that are under administration.
No, it's fine, Minister. I think you'll provide that report.
Okay, but I need to know what report you're looking for. Or maybe you can put it in writing, we can look at that.
I
Sure.
think that is the simplest way because now we want to be technical. I've been explaining myself which report am I referring to.
Okay.
Let's leave that one of SETAs and basis of placing it under administration. I think that one is a discussion for another day.
Hold
Can
on, I've just posted some time. So, Minister, I think the question moves from that you received the report that did analysis of all 21 SETAs. And it is on the basis of that report that you then put the 3 SETAs, the report that you received from the National Skills Authority, that you put the SETAs. Okay, what did you say?
No. So yeah, I think we need to be clear. So it was not the only reason, the report from the National Skills Authority was not the only reason why the SETAs were put under administration. I think we put a comprehensive report, Chairperson, on the 19th of September as to why we put each of the SETAs under administration. And the NSA report was not just the only reason why we've, I can always get back to those reports as to why we put those 3 SETAs under administration and furnish them to Honorable Khabu.
Yeah, so the meeting of the 19th, I can't remember which member asked, but they asked you, what was the yardstick that was used to determine the dysfunctionality? If you
Okay.
remember
Yeah.
the gazette
Yeah.
that the minister issued in putting the SETAs under administration, it would have said governance dysfunctionality, maladministration, and all of these things. And then in the meeting, we then asked that the minister must then provide us with that report in writing. Because amongst other things, or in fact in the meeting we said, give us individual reasons, not a comprehensive as it was put on the gazette. And I was just asking Anela if we do have that report. I don't remember seeing that report, Minister.
We can send that report, but let me give you an example, Chairperson, with regards to, say, LG SETA. So I received a letter from the Minister of Finance that says, I have received a report from a whistleblower. I've conducted a forensic investigation. These are the findings. This is what I recommend you to do. So it's not the NSA report. But when I listened to the NSA, they said there are additional measures. So that's why I'm saying that the NSA report was not the only basis. The AG's report is not the only basis. So it's a collective, or rather it's a list of issues that we relied on, which I thought we probably canvassed on the 19th of September in terms of each of the SETAs. We can provide you with additional information from the National Skills Authority. I'm committing the CEO to send the report, if we haven't by tomorrow, which was a presentation I received from the NSA, I think 3 or 4 days after I was appointed.
No, thanks, Chair. I think the report will then be in two folds. The one that will speak to those that you did not place under administration based on reasons that I will present to you in my formal request, including the reasons for the 3 that you had placed. Now that it's not only the NSA and AG's report that led you to placing the 3 under administration. Hence, I'm saying that the report will cover 2 aspects if we understand each other, Minister.
I don't want, so, yeah, but my point, Chairperson, is I was called on the 19th of September to come and give reasons why we've put 3 SETAs under administration. And we gave those reasons, and beyond giving the reasons, what was asked of us from that meeting, of me actually, was whether have I consulted with the National Skills Authority, which I did, but over and above having consulted with them, I also indicated that they had given me a presentation at a meeting, in addition to all the other factors, a presentation in a meeting that said, this is the situation with, these specific SETAs. So I don't know if you want me to still send you the report which I gave on the 19th of September on why we placed the 3 SETAs under administration, and the report from the NSA, or should I allow you to write to me and I look at what your request is and comply with that request?
I think that is the simplest way.
Okay,
Let me write
all right.
the request.
Thank you.
Because knowing the minister will spend the next hour, he will be playing with words, and the next thing, my 15 minutes will be done. So I'll write you a request on what is it that I'm expecting. Let me go to the vetting process, Minister. The vetting process.
Okay.
There's been issues that we have been raising as a committee on board members who have been identified by forensic reports. And instead of consequence management being applied, the next thing that you'd see is that the board member will be moving from one board to the other board. I'm much more interested on the vetting process. To which extent are you conducting those vetting process? And what would be the difference between the previous vetting process and the current vetting? Because the previous vetting process, to a large extent, has produced some individuals with questionable characters, especially from a financial management point of view. So can you take us through in terms of that process of vetting? To which extent are you vetting these individuals? Thanks.
I think there's an MIE process which requires us to look into a certain thing. I think it's criminality and all of that. And so we did that with each of the accounting authorities, all of them for all the SETAs. We've also, even with the CEOs, those who were reappointed, we've also done the same exercise. And yeah, unfortunately, that's the only tool that's available to us. And that's the vetting also vets people on the basis of what's required by the Act, that they must not have criminal records, I think, amongst other things. So that's the kind of vetting that we do. So I signed off the letters for the appointment of the accounting authorities, for instance, on the 12th of September. And we could only get the feedback for vetting, I think about 21, 22 days later. And that's how we take that process quite seriously. Thank you.
No, thank you very much. I think part of the request that I would make from you would be to give us a difference between the previous vetting, that was conducted and the current one. Because I've made an argument that the previous vetting, to a large extent, has produced people with questionable characters, where they've been identified in forensic investigations. And unfortunately, the department, because of their own reasons, they would not implement that forensic investigation. That's why in most cases, these people tend to appear in other boards, whereas in other boards, they were identified as problematic. That's why I was checking what it then becomes the difference.
Yeah, well, nothing different. It's the whole MIE, and I think besides the fact that the process also produced, people who I think, as you say, with questionable conduct, it has also given us people who are good, who did quite a good job in the work that they do. And I think if members of parliament feel that we need to change the vetting system to impose more requirements on the board members, I think let's change the legislation.
I think it's noted, Minister, but like I said, I'll make that clear request as to what is it that I need from you. Let's speak about the disparities that are there on your remunerations of your CEOs. When you had the other day, the Minister of Finance claiming, I'm not sure how true is it, I think the CEO is here, he'll clarify, that the CEOs of NSFAS salary is above the one of the president. But that is a discussion for another day. Let's go to these ones of SETAs. Apparently, Service SETA, according to that report that we had received, the CEO is earning 6.8 million. MI SETA and MER SETA is earning 6.2 million. Even if you can doubt it, Chairperson. Now, on your presentation, is Mr. Mabuzela pressing the mic again there?
No, it's just I was denied the point of exigency. The chair.
No, my question was on and around the disparities. What are the figures? 6.8, 2.4, it's a discussion, but the reality of the matter is that there are disparities. I would want to check the determination and why, to a large extent, are we allowing such huge gap in terms of disparities? I mean, before us here, when they speak of SETA accounting authorities remuneration, and as per the report here, this document was sourced in this current year. Service SETA is 6.839 million. MIC SETA is 6.2. MER SETA is 6.2. I think I've made, I've given you the two questions, and I was just making reference because earlier on I had some sounds as if I'm not counting or I'm not mentioning the figures correctly, as if I'm from one village there. Thank you very much.
No, no,
As-
let me just, no, let me just help. The document Honorable Khabo is looking at is not the remuneration of CEOs, but the total remuneration of all board members, including travel and hotels. So what is making reference to that one, not CEOs.
Can I then rephrase my question?
Yeah.
Now, you see, when you begin to engage on issues of CEOs, Minister, you see members of the portfolio rising on defense. This thing must be looked into. It's a discussion for another day. It still boils back.
It's something I should pay attention to.
Yes, you must have an inquiry. We'll also have an inquiry as a committee on this matter. There seems to be an unholy relationship between some of our members and CEOs. My issue was on and around disparities. What would be the actual reasons for such huge gaps, even if it include the entire board, including their work? Can you just take us into confidence?
Okay, I'm not sure about if there are any disparities in terms of SETA CEO salaries. I thought that they are the same, but I can ask either the acting DDG or the CEO of the NSA to confirm. I don't have that information at hand. Yeah.
No, Minister. No. Unless you want to abuse my misinterpretation of facts of earlier on. I've rephrased my question. Now that I was corrected, that it's not meant for CEOs.
Okay, yeah, but then I wouldn't know the details. I don't know what influences the board's travel and all of that. I think we might have to go deeper into that to give you a clever response.
Yeah, we did, I think, NSA presented the thing to us, and they had indicated in the case of one SETA that the chairperson, for an example, will travel from Kokstad or that far and then drive to Durban, and then sleep in Durban because it's far, then fly in the morning to Johannesburg, sleep in Johannesburg. So they did explain the variety. Others, it includes overseas travel based on what they would have, but if there's something you want to quickly clarify.
Thank you, Chairperson. So I think, and Minister and honorable members, good evening. I think we need to separate the board remuneration from reimbursement. And because those, and for accounting purposes and reporting, they get combined. But if you read further, you'd find that they are disaggregated in terms of what purpose that was for. So there are those that are for reimbursement and those that are remuneration. Like in the case in point the chairperson is mentioning. But they must still be reflected to say they were for whose benefit. So in the respect of the salaries, the regulations on the appointment of SETA CEOs and the conditions of service, it says their remuneration would be at the same as that one of the public service. However, it depends when the appointment was made, because we could be both be CEOs, but if he started 3 years back and I only started this year, the cost of living adjustment that takes place during the course of the service would obviously warrant that the person who started earlier be adjusted. So by the time I start, I would be at a lesser notch. There are indeed cases of CEOs that were there before the regulations were introduced. And in terms of the Labor Relations Act, we cannot erode their income and by implementing the provisions of the regulations retrospectively. Thank you, Chair.
No, I think, Chairperson, maybe in closing, we'll just have to get that breakdown so that we are able to make that assessment as to how much are we invest in terms of disbursement and how much are we then spending, so that we are able also to deal with that challenge of CEOs being appointed very fine, as a result having to spend a lot on traveling expenses. That is one aspect, if we can request. Maybe, Chairperson, as part of closing, maybe one must request the issue of diversity from the minister. This issue of youth representation on your SETA boards and your councils. It cannot be correct that when young people are in majority in this country, your appointments continues to reflect a reaffirmation of the old age center people in government. We must not accept that thing, and we are going to plead with you as much as the process would be reliant on you on observing key issues like your academic background. It is our firm belief that we still have majority of young people who have the necessary academic background to make a full representation on this, on these boards. And the last issue is that one issue that we had made mention of is how we must then look into this process of it being transparent, especially of these powers that are vested in the minister, not necessarily questioning the powers, but questioning the turnaround time, so that the turnaround time is aligned to the process. Because what we have seen playing out there, it's how we would want to interpret the law based on our own observation, and of which I think to a large extent the law now protects you, and we'll have to look into that as a committee. Thank you very much.
Thank you very much.
Thank you. I think with regards to youth, would really want to do much more than has been done. But I think it's important that honorable members understand that we receive the nominations from business, from unions, from the community constituencies. And so where applicable, we tried as much as possible to take into consideration, people's age. So we worked with what we have. And so, unfortunately, if we do not encourage organizations, constituencies to nominate young people so that we, consider them, then that's something else. I must agree with you that having just 20% of the people who have been appointed being between the ages of 30 and 35 is a concern. And I think it's something that needs to be worked on into the future. I will look at what the numbers were in the previous term. I know that it was a major concern when we presented the report the previous time. And I'm hoping that there's an improvement. But I think the call is for constituencies to prioritize youth and also to prioritize women so that we're able to achieve the parity that is required. Thank you.
Honorable Lonzi.
No, thank you very much. I didn't want to
Sorry, Chair. You would realize that it's my new sitting partner, so we decided to interject. Minister, just on that, I wanted to ask, before that we can proceed. I wanted to know, Minister, with regard to the question, as you say, they're applying, do you think that should we rather codify the skill, this particular thing of diversity in the Skills Act, or should it depend on your ministerial discretion? What do you think is best so that we're able to have it compulsory rather than that? Thanks.
Well, I mean, it depends. There are SETAs where we had 80% nomination being men in terms of the accounting authorities. And I think you will check, we didn't appoint the full complement because, I couldn't live with myself having to do that. And we're hoping with the further advertisements, the constituencies will consider, nominating young people. Yes, we should consider that. Whether it lies with the minister or it lies with the legislation should compel, so that if it doesn't balance, we should take it back, so that's something else. But I think measures have to be taken. Just as an example, Chairperson, one of the unions, nominated 5 people, and all of them are men. All of them are above the age of 35. And they strongly argue that all of them are eligible to serve in the SETA. We cannot dictate to them who they should nominate. So those are the kind of dynamics that we'll have to deal with. And I suppose we should consider when we effecting legislation.
Honorable Lonzi, maybe if you have one union nominating 5 males, you don't have to consider all of them from that particular union alone, because it's labor. So you look at other unions who are progressive in thinking, in helping us drive the agenda of what we want to achieve. I mean, the women, youth, people with disabilities have always been oppressed on the basis that they are women, they are children, and all of this. So unless if you're saying, if you have 3 unions participating, all of them just brought males, I think
in some cases, yes.
Yeah, I think we must just those ones write back to them and say, no, we're not taking it. We must bring, I mean, we're not, we can't be reversive in before maybe I give you Honorable Lonzi. Those of you who want to grab something to eat, okay, I've got a proposal. So
Does that include me, Chairperson?
Yes, I've got a proposal. I've got a proposal because the problem is this people from the minister's office and the DG's office have been finishing food there. So, no, it's the truth. So I want to check with you members. What do you suggest? We take 10 minutes. or we continue? Or those who then want to grab something, you can then go, do something that side. It depends on what you want to do. I just don't want you tomorrow to say, I gave you permission, Minister. I did not give you permission to go eat. Honorable Lonzo?
Let's push, Chair. Minister, don't fall for that trap. I didn't want to speak on this thing of administration because my focus will be on the CEOs. But because Honorable Khabo raised it, there's an interesting point that I want to double check here, Minister. Who consulted with the National Skills Authority on the 7th of August regarding placing the 3 seaters under administration?
What do you mean who? I consulted with the Skills Authority.
And the reason I'm asking you that, Minister, is because when we asked the National Skills Authority to send us the minutes and the agenda of the meeting of the 7th of August, your name doesn't appear on the agenda.
Okay, so what's the point?
So you were present in that meeting?
No, I was not present in that meeting.
So I don't understand, because you consulted with when did you consult with them?
I wrote to the National Skills Authority indicating my intention to place 3 seaters under administration, and the National Skills Authority wrote back to me with their advice as it relates to those 3 seaters.
Chair,
So consultation doesn't mean that I have to call a meeting, sit down with them, and then say, okay, so this is what I want to do. What do you think? So consultation means that I've solicited their views, which is in this case what I did was to write to them and say to them, this is what I'm looking for.
You wrote to them on the
Do you
7th of
agree with-
August.
I don't have the details. I'll have to check the specific details when I wrote to them and all of those things.
So you've never set a meeting with the National Skills Authority as minister?
No.
Okay, whilst I move to the other points,
When
can,
you, okay, so I had a meeting with the chair and the chief executive officer of the NSA on more than one occasion. Yeah.
So consultation for you is writing a letter and then receiving a response to the letter. It's not sitting an official meeting with the National Skills Authority or the SETA, and then you tell them of the reports. The Minister of Finance has given me these reports. Then you have a formal meeting with the National Skills Authority. You don't consider that to be consultation. According to you, consultation is you send for example, if we wanted to consult the minister, we'll send an email to you, you respond to us, and we consider that to have been consultation.
Well, I mean, as they say, some meetings can actually be correspondence. I think that what I'm required to do is not the form the consultation should take, but is that I have actually satisfied the requirements of the law.
Okay,
that I've
when I
solicited
move on,
their
Minister,
views. Thank
can you ask your team, which I believe is here, to please try and get the letter for us that you claim you sent to the NSA as part of the consultation, so that we can get the date.
We can check that.
Yeah. Now, I'll come back to this point. What is your understanding of a transparent process, Minister?
Transparent process.
Yeah.
I don't understand.
Let's say you want to appoint someone, or maybe let's bring it closer to home. Let's say you want to appoint a CEO, and for you to appoint a CEO of any entity. Okay, it's fine. Let's bring it to the SETAs.
Yeah.
Let's say you want to appoint a CEO of the SETAs.
Yes.
What is your understanding of following a transparent process in that process of appointing?
I don't know if I'm required to. I think the Act stipulates the processes I should follow, and I followed those processes.
No, I'm not. Sorry to interject, Minister.
I don't know how transparency applies here.
I'm not disrespecting your apologies, Minister.
Yeah.
It's just that we've got limited time, so I
Okay,
want us to be
all right.
interactive. I'm not asking you about what you did. We're still coming there. I'm saying you are, as a minister, you are given a task to appoint a CEO. And in appointing the CEO, you are required, you want to follow a transparent process. Just quickly, what is your understanding about following a transparent process in appointing a CEO?
Honorable Lonzi, unfortunately, I'll have to be specific because, firstly, I'm not required by law to be transparent in the context within which you raise. That's why
No,
I
I'm
said,
not. I'm not asking.
So
what
I don't know
you're
what's
required.
the you know what.
I'm just asking you, Minister, what is the definition of a transparent process? Like I'm still coming to the requirement. I'm still coming there. I'm saying you as a minister, the people of South Africa are saying, okay, maybe let's move away. Appoint a CEO of NSFAS. And in appointing the CEO of NSFAS, please follow a transparent process. What is your understanding as minister of the definition of following a transparent process?
Well, the definition is that I must follow what's in the law. That's as far as I'm concerned. What are the step-by-step stipulations in the law? And if I follow what's in the law, I deem to have satisfied its requirements. And I have not been asked before to comply to transparency. I don't know what it means in terms of the appointment of someone.
Minister, I'll come to your legal because I think you are trying to play with words here. Because it's a very simple question. What is a transparent process? Like I don't think it's something that needs you to go, around. But I'll come back to you, Minister. I'll come back to you on this point. Legal of the head. What is your understanding of a transparent process?
Thank you, Mr. Lonzi, for your question. I think without being legalistic in giving you a definition, a transparent process would be a process that is acceptable, that is rational, that is reasonable, that is lawful. And
Thank you, legal. That's all I wanted from the minister. It can't be that the minister can't tell me what his understanding of a transparent process is rational, it's reasonable, it's lawful, it's logical, the things that you're saying. Now, Minister, when did you send the letter to the accounting authorities to recommend to you the appointment of CEOs for an additional term of 5 years? Which date did you send them that letter?
Sorry, can you repeat the question?
When did you send the letter to the accounting authorities? Maybe let me start it a bit, David. When did you appoint the accounting authorities?
Well, they were appointed on different periods, but most of them on the last week building up to the 30th of September.
Building up to the 30th of September. When did you send the letter to the AAs instructing them to recommend CEOs to you for an appointment of additional term of 5 years or acting CEOs?
I think around the 28th of September. I'm subjected to correction.
I'll tell you, Minister, you sent them that letter on the 29th of September.
Okay, yeah.
And then in your letter, Minister, you say to them, go and sit an urgent meeting. You have got staff members here, they must take out the letter so that you are fully aware. There are people who are sitting here who don't know what they're doing. You said, on the 29th of September, go and sit an urgent meeting and then recommend to me appointments of a CEO for an additional term of 5 years. Mind you, these are accounting authorities which have just entered office. Yes, there may be some of them are repeating, but they've just entered office. You are saying to them, in less than 24 hours, please give me a name of a CEO.
Yes.
That's what you said to them.
Yes.
Now let's go to the Act, Minister. The one, so you and legal, you rely on Section 8. Section 8 says, a chief executive officer may be recommended by the respective SETA in terms of sub-regulation 6 for appointment by the minister for a further term subject to satisfactory performance. We're still coming to satisfactory performance. Subsection 6 then reads, the accounting authority must make a recommendation to the minister within 6 months of taking office after following a transparent process. Recommend in writing 3 qualified, experienced, and suitable candidates with knowledge in accounting, finance, senior management, matters of appointment, blah, 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 of the CEO to the minister. Now, the section that you are relying on with your legal says, it's fine, if you want to reappoint someone for an additional term of 5 years, you may very well do that as a minister. But you must do it in line with sub-regulation 6. What does sub-regulation 6 say? You must follow a transparent process. Now, let me ask you, Minister, what transparent process would those boards have followed in less than 24 hours?
So when I started, I indicated that we appointed the accounting authorities under completely different conditions, which were not under of any of our choosing. And just as I faced the pressure to make sure that the accounting authorities are appointed on the 30th, by the 30th of September, they also had the responsibility to make sure that they,
And I know, Minister, last time we had this problem. I hope you don't feel like I'm disrespecting you. I'm only doing this for pressure.
It's not disrespect.
I don't
think
want
it's
you to give me
important
that context.
I'm allowed to respond.
Because you've already given us that
Yeah,
context.
yeah.
I mean, it was
but-
in your
yeah.
presentation.
So-
My question is, the Act is saying you must, even if you want to recommend CEOs to be CEOs for an additional term of 5 years, you must follow a transparent process. I asked you, can you define to me what's a transparent process? You went to town, you didn't give me a definition. I then went to legal. Legal says it must be reasonable, it must be rational, it must be logical, and all of that. Then I say, how do you send a letter to a board that has just entered, by the way, to make an appointment of a CEO for an additional term of 5 years, and this name must be submitted to you in less than 24 hours? Which process could that board have followed that is transparent?
So, Honorable Lonzi, there has to be a distinction between two processes. The first one being, who do we recommend for reappointment, or rather not even reappointment. I think the Act and Regulation speaks for further appointment, which is the incumbent CEO. And what the accounting authorities is required to do is to make an assessment of the performance of that particular CEO, and on the basis of that, make a recommendation.
One meeting, Minister.
I believe that the accounting authorities were given reasonable time to be able
24
to do
hours.
so, and that if they were unable to do so, they would have indicated that they are not in a position to do so.
Let me come to you, legal. Since you, legal of the department, you gave me a definition of a transparent process. Which transparent process could these boards have followed in less than 24 hours? New boards that have just entered. Did they sit an 8-hour meeting where they went through all the reports of the SETA? What transparent process could they have followed?
Honorable Lonzi, in this context, I would imagine that transparency would depend on the diligence of the AA in doing their work. If they want to go through all the reports within or overnight and working like we are doing right now and be there for the whole day, then obviously the transparency would have applied because they would have gone through all the processes that they need to go through them. There are no time frames that would have applied in the circumstances, because I would imagine that each case has got to be treated according to the facts of the case. Thank you.
Askisa, Honorable Lonzi, so I think this is linked to the submission I made earlier. So I'll tell you what happened. Two things happened, Minister. You are correct in your assessment that Dr. Nkabane had left you with a mess and you had to catch up because time was expiring. And that was not a circumstance.
I have said no such things.
And because
I think
time
you
was
need
not
to
on your-
indicate if you are saying that and
I am
without
saying
putting
that
it
for
in
sure.
my mouth. Thank you.
But
Sure.
you are saying the circumstance was not of your choosing. So I agree, it was not. And you knew very well that come 30 September, the employment of these CEOs would have lapsed, that they would have ceased to become CEOs. And it is on the basis of that, that under the pressure which you identify yourself, that you quickly had to appoint the boards and then give them 24 hours to reconfigure themselves and give you the recommendations of CEOs. But you also knew that even if their recommendations came on the 30th, that you wouldn't have concluded the appointment process yourself to align with the expiry of the 30th of September, because you would have only received the recommendations of the 30th of September. That is number one.
You are deviating from the question. I thought you are following up on his question.
No, the question is on the process, on the diligence. So I'm there about the reason why. So I'm there, Chairperson. Agree? Honorable Lonzi is speaking about there's no way in 24 hours there would have been a due diligence that was followed. And so the point I'm making here is an expansion on why there was a risk of that due diligence not being followed. Number two, the reason why you wrote, Minister, to these accounting authorities to ask them to give you the recommendation of an extension of 5 years is because you knew that they couldn't have given effect to subsection 6 of subsection 6 of the regulations, which say that they would have gone through a recruitment process or a transparent process before the deadline of the 30th. Is my understanding correct?
No.
Yeah.
Can I just say something?
Yeah, maybe before. Okay.
I didn't know any of those things. And I think what we're disregarding here, Chairperson, is that all the SETAs made recommendations and varying recommendations. Not all the SETAs recommended an appointment of the incumbent CEO. So that's yes. And secondly, that so from the 25th of August on or about, we open up the nominations for a further, I think, 7 or 15 days for accounting authorities. We start considering all of this towards the middle of August, and we work throughout August into the 12th of September, where we inform all the SETAs that these are the accounting authorities that they need to consider for appointment. And throughout that process, an MIE process takes place, which gets concluded around the 27th, 28th of September. We inform this, the accounting authorities that if they don't recommend to us as to who's I didn't say to them, extend people. I said to them, this is what I'm looking for. Either an appointment of a substantive appointment of a CEO, or for you to recommend an acting CEO from 3 names, and then start the exhaustive process that that Honorable Lonzi is talking about. So the transparent and exhaustive process is the one that the accounting authorities are required to follow once they do not further appoint the incumbent CEO, which is
That's
what
not
the
true,
9
Minister.
CEOs,
That's not
which
true.
is what which is what the 9 SETAs are doing, those who did not have acting CEOs in place. I don't know if whether true or false is the right word, but that's my interpretation of the implementation of that law, or application of that law.
Okay, Dr. Mabuse.
Thanks very much, Honorable Chair, for the opportunity. My point is simply that sub-regulation 8 is kind of conflated with 2 processes. And I actually indicated this before. I agree with Honorable Lonzi to say that relates to issues of transparency, issues of consultants and so forth. But then here you are dealing with 2 processes, which you must view them in context. As soon as you remove context, then that creates a problem. Now, when you appoint a new CEO, Section 8 applies in a broader context because you are dealing with a huge quantity, which will take you days to finish it. In this particular process, in terms of the Gazette, we are dealing with one person. And how long does it take to interview one person? 30 minutes, 1 hour. And therefore, to speak of a process that should take days, you can give even the AAs, the AAs. You can give even the AAs hours for them to complete that person on one person, as long as they have aligned themselves with Regulation 8. That's all that is needed.
Madam Mabusela, do you know what the minister wrote to the AAs?
I was briefed on that, Chair, when I came on board.
What was written? What was an instruction?
You have explained that, Chair, to say, actually, I wanted to
No, I've
come
not
in there,
explained.
but let me
I'm
answer.
asking you,
Yes.
what was contained in the instruction from the
It's a
minister?
supplementary instruction.
What does it say?
That does not create a new provision.
No problem.
Instead, it clarifies what
no.
needs to be done.
No, that's a second letter. I'm asking
Yes.
about the first letter, the instruction that you are making the subsection 8 reference to. So you should know. You can't say you don't know what was the context. Because you are saying to us, these boards were dealing with one person. It takes an hour, 30 minutes to interview a person. That's why I'm asking you, what was contained in the letter?
No, I think, Chair, you were not on the same page.
Okay, let's
Let me just explain myself.
no, answer me. Do you know what the letter of the minister said first?
Yes, the
What-
letter
what
of the
did-
minister was saying appoint, in fact, not appoint in this case, but extend CEOs that are already there.
No, but was that what the minister said?
Yes, the letter.
Extend the CEOs that are there.
Further appointment.
No, the letter of the minister says.
Further appointment.
No, isn't that Mabuzela? This is not the first time. No, this is not the first time. I'm doing this intentional. Because I've told you before. If you don't know something, don't enter things where you don't know. Because the explanation you have just given is not assisting the process. No, subsection 8, sub-regulation 8, It doesn't, we must just agree.
I
Because you
disagree,
don't
Chair, with
know.
due respect.
No, you don't know what the letter of the minister says. So you can't tell us about sub-regulation 8, and then you want to tell us that it takes an hour to finish interviewing or 30 minutes one person. There was no interview in the instruction of the minister. That's why I'm asking you if you know what is contained in the instruction letter of the minister.
Chair, the instruction of the minister was simply saying the AAs must perform their primary function. And the primary function was to ensure that there is a CEO there in those SETAs. I'm saying this because the skills branch has interest in this matter.
Hold on. And those AAs, if that's what the minister wrote, those AAs said, and both the minister and Advocate Kuta said, the minister had to rewrite to them. If that's what you are saying, that was the letter of the minister, then you are saying they are misleading us.
No.
Because you are not listening to me. You are saying the letter said, go and make sure we've got accounting of officers. That is what those people did. But the minister then wrote back. It was just explained now. wrote back to say, you did not understand the spirit of my letter or the contents of my letter.
Precisely, Chair. That's what I'm saying.
No.
That's what I'm saying.
What are you saying?
Hence, I'm saying what Honorable Lonzi is saying by invoking the issue of transparency. He is using that provision
What
in a
provision?
context that explains as though we are dealing with a huge number of applicants.
No.
Whereas this process is simply saying, for further appointment, there's only one person whom you consider there.
But
You
I'm
don't
telling you-
consider 30 people and a really
That the
affliction
Mabusela,
of time
now
there.
you are wasting our time. Honestly speaking, you are now wasting our time. Because the minister just corrected that. That is not what he said. You want us, you want to test us on something that is really unnecessary. Unnecessary.
Suppression, Chair.
You are, Nadamas Busela, you are wasting our time. You want to mislead us here. You don't know the contents of the letter. You don't know it. There's an instruction of what the minister says. And I've asked you, I don't know, many times. And the reason I was asking you is because this is not the first time I say to you, you are not part of this process. You know, to say I don't know, because we are not part of the process, it's a very noble thing to do.
But Chair, in spite of whatever, I'm the acting TDG
Okay.
for skills.
So you know.
range. And therefore, these things are within my purview.
Yes.
And the fact of the matter is that, Chair, if I may be given privilege, in
to do
terms
what?
of the South African law,
Yeah.
we are equal in front of the law.
Yes.
We are all equal.
And if you lie here,
I'm not
in
lying.
front, no, you are. In
I'm
front
just-
of this law, we must then use section 17, subsection 2, because we are equal before this law.
Chair, that's not
Those
fair.
who pledge
That's not fair.
in parliament, lie in parliament.
That's not fair.
No, what is not fair?
That's not fair. That's not fair, really.
Chair, I just wanted to assist so that maybe the minister can assist us. Maybe this time the minister will be decisive.
No,
To read this point that he's saying the minister said, which was, because we can't dilly-dally around this matter.
no, we'll deviate. That Mabusela was just speaking something he doesn't know.
I don't agree, Chair.
The minister must help
You
us.
just, okay. All right. Thank you, Chairperson. So the 6 months window that Honorable Lonzi is talking about applies from AA appointment in terms of, and it's not linked to to the COs who were incumbent. The COs who are incumbent, the accounting authority considers them in terms of a further appointment based on their performance, and they make their own assessment. And as to whether they had sufficient opportunity to do that or not, that's something else. But I suppose the fact that I received a recommendation from the accounting authorities, 9 of those, in terms of further appointment of the CEOs, means that they've applied their mind. I've got no reason to doubt that, unless if we want to put that to a test. And then so as I said, then the 6 month, the 6 months window that you spoke about, that the accounting authorities have to follow, is when they are involved in the substantive appointment of a CEO after having recommended, an acting CEO. So basically, that's
No, I know that one, Chair. I'm not talking about the appointment of an acting CEO leading to a substantive position.
Okay.
I am saying, even when you want to recommend the reappointment of the current CEO, you ought to follow a transparent process. Because even the letter you write, Minister, which Tati Mabuza clearly never read, it says here, or, so you give the option of the acting CEOs, and then you say, or, submit a recommendation in terms of sub-regulation 6 and 8 for the appointment of the current Chief Executive Officer for a further term of office ending on 31 March 2030. I know the law very well about the acting. What I'm saying is that in your reappointment of these 8 CEOs, I'm not talking about the act, I'm talking about the 8 who have now been given an automatic, essentially an automatic extension in being CEOs for 5 years. There was no due and transparent process that follows. And I've demonstrated that clearly to say there is absolutely no logical claim you can make. I know legal will try to speak around this, that I can send a letter to an entity today that has just entered, by the way, and say to them, please assess this, sit an urgent meeting, which means they only said one meeting, sit an urgent meeting and tomorrow give me a name that I must reappoint as the CEO. You didn't do that, Minister. And because we're going to follow up on this point, Chair, we're going to request the minutes of those particular board meetings where these, particularly these 8, Chieta, MQA, Foodbev, FESET, SETA, WNR SETA, FP and MSETA, MICT SETA, where CEOs were essentially just given an automatic extension without there being following a due process. Now, let me come to this point we were trying to make earlier on, Minister. The Section 8, in the way we interpret it, is that the current CEO can be appointed for a further term of 5 years. But once the contract finishes, which it finished on the 30th of September, that CEO no longer has a legal relationship with the SETA. Therefore, we don't view that person as the current CEO. He's unemployed, like all of us. Okay, well, I guess we're not unemployed, but he's unemployed. He's not the CEO. So for you to then, and I put it to you, Minister, that's why even in your first letter, you were very clear that these people must sit urgent meetings. Because you wouldn't have said they must sit an urgent meeting if you didn't have that pressure of the 30th of September. I put it to you that you had that pressure of the 30th of September because you knew as minister that if I want to appoint these people for a further term of 5 years, I must make this decision whilst they've got a legal relationship with this particular SETA. You didn't do that. You are saying to us you are interpreting the act differently. You think the AA can recommend, but the minister can make an appointment after the fact. So here I just want to get information from you, Minister, because we've had the interaction earlier. When did you officially make the appointment of these 8 CEOs for a further term of office? Which date?
But I think it's important, Chairperson, because I think Honorable Lonzi has made statements as statements of fact, and I think it's important that we correct those. Firstly, there is a requirement that by the 1st of October, there has to be a chief executive officer in all the SETAs. Otherwise, that's misgovernance. And in instances where SETAs are unable or accounting authorities are unable to appoint a SETA on the 30th, they are then required to give me a recommendation of 3 names of senior managers whom I will consider for appointment.
Yes.
Yes, and so not all, because you're making an assumption that all the
senior
SETA
managers still have a legal relationship with the SETA.
Yes, they do.
I agree with you on that one.
On the 30th of September, when the accounting authorities make recommendations, the people that they recommended had a contract existing with those SETAs. And that point is important because it's also linked to your actual question. And so the Act obliges the accounting authority to make a recommendation on the 30th of September, in this case, which is the agreed date. As to when I apply, I wouldn't have known. The Act would not have assumed that I would not be able to effect, or concur with that recommendation, on the 30th of September. Unless if you suggest that I was time bound, firstly that the the accounting authority itself was time-bound outside of the active contract of the person who was appointed. Secondly, that I was also time-bound beyond those points that you raised, rationality and so on and so forth, that I was actually time-bound to act by the 30th of September, which I was not required to.
But you
Yes,
required
you
the
can.
AAs to act by the 30th of September.
I'm not requiring the AAs to do so.
But
It is the law that requires the AA to do so.
But they wouldn't have done that in a transparent process.
They should
Minister.
have done that. They are expected to do that by the law. If they do not give me a substantive CEO or an acting CEO recommendations, then they would have been subjected themselves to, to bad governance. That's what happens. You cannot make a suggestion that unilaterally I extended the terms of office of the CEOs. There was no extension
I think you
of
did, Chair,
any
but
of the CEOs.
I don't want to
I did
waste
not
the
give
time.
anybody
Just give the
names.
date, Minister. When did you make the appointment now?
I wrote a letter to concur with the with the different accounting authorities on different
There
times.
are 8 of
on
them:
2
Theatre,
occasions,
MPA,
yes.
Footbear, Facet, INSETA,
Yeah.
WMIC, SETA. These ones that you
I may
appointed
not
for
know
5
the
years.
actual date, but I know that it was after, because I think that's the point you're trying to make, that it was not on the 30th of
It
September.
was after the 30th
Yes,
of September.
yes.
Well, your letter of the 6th says they must submit by the 10th of
Yes.
October. And you probably write the letter back to them after the 10th of October.
I don't understand what you just said.
If you are saying they must submit by the 10th of October, which is your deadline, it means you would have appointed them after the 10th of
Possibly,
October.
yeah, but almost definitely, yeah.
So this is where I'm coming now to the point that you are making. Now, on the 6th of October, you then realize that these accounting authorities...
Hold on 1 second, Honorable
Oh,
Lonzi. But the Mabusela, you have your hand up? Or you are covered?
Chair, you make me to be covered, but really, the fact of the matter here is that you are the legislatures, and you do legislation, and you give that legislation to us to implement. And now, here what we are trying to explain is the fact that it's not an issue, the question of the 30th of September 2025. The fact of the matter is the deadline for the AAs to take a decision was met. And there was no AA to which I received a letter from them complaining about pressure being placed upon them to undertake a certain process. No, there wasn't. And therefore, as the department, you have acted within the law, and the law that has been prescribed by yourselves. That's why I'm saying to Honorable Lonzi, the fact of time here, time affliction is
Chair,
not,
I hope you have
not really...
paused my time because I don't know what this
not-
gentleman is talking about.
I'm talking about the 6 months. The 6 months of the appointment of CEOs, to say within 6 months. Those are new CEOs.
Yeah,
And
let's
here
leave
we
it.
are talking about the
you're not listening.
the
So
right
the-
term,
Tate Mabuse, you're not listening. Honorable Lonzi is talking about 7 or 8 CEOs who were, to use the correct word, what is it? Further term. He's talking about, so leave 6 months. 6 months doesn't appear. He does not talk about those things. He's talking about these ones.
that's my argument, Chair, to say,
No, let's leave it.
Yes.
You have won it.
can you get my argument to say why I'm quoting that? I'm simply here making a contrast to say, if I am a minister, and I'm supposed to then allow AAs to make an appointment of a new CEO,
AAs
The
don't
law-
appoint.
the law will prescribe the process that I must follow,
Yeah.
okay? And there I would expect a huge number of applicants. That's not the process that Section 8 refers to in this case. Section 8 in this case refers to further extension. That does not include a huge quantity of people. And therefore, to come and argue about
Point of
the
order, Chair.
30th
We're
of
just being
September,
abused here. by
30th of
just
September, it's
ignorance
not-
of
not
someone who
fair.
should. I'm not talking about a big number of people who are applying. I'm saying to you, even Section 8 says it must be read in line with Section 6. And Section 6 speaks about a transparent process. I don't know why you keep talking to me about 6 months, because I've already clarified to the minister that I fully understand who the 6 months refers to. The 6 months refers to if you put an acting CEO and the AA wants to go on a fully blown interview and advertising process or finding a substantive process. That's where the 6 months comes in. I'm not talking about 6 months. I'm talking about these 8 who have now been reappointment for the further term of 5 years. So please, Chair, I want to continue.
Which actually made
I don't
the
know, I don't know
deadline.
what this gentleman is talking about.
Chair, let us beg for your protection from this member of the department. He's really abusing this committee and then us, and then it's abusing our time. We've been here since 9. Maybe he doesn't mind. We mind. Please protect us, Chair.
I just have one quick question. Minister Manamela, Agrakwena alatile Ntate Mabusela wherever he was and decided hore it made sense to appoint him the DDG, acting DDG for skills development. How did you get to that decision? Ngempela, because like for us, we're sitting here now. It's part of the questions I would have asked with my time. But the fact that your own DDG responsible for skills development is having a submission about what is what and what is not what that is in stark contradiction to your comprehension, how do you then expect us now to have confidence in your consideration of Ntate Mabusela? Let alone the fact that we still want to know what happened with the investigation on the 1.3 million NSF.
Do you want me to respond to that, Chair? Okay. All right. So the contention, which is what acting DDG Mabusela is raising, is that what we're contending about here is that the accounting authorities had an option to either further appoint the substantive CEOs. The CEOs were incumbent, and that appointment could have only happened if those CEOs were active in office, which is the option that those accounting authorities had. And that's what they took into consideration. So 9 of the SETAs took that into consideration and recommended that we should further appoint in a new contract. It's not an extension, in a new contract. And so if I think honorable members believe that there should have been an imposition in terms of the time, which is not required, by the way, by law, as to how long only that consideration has to be made, on a particular day if it involves those individuals. As to the rest of the other SETAs, I think the process is unfolding, and I think we will deal with that process when we get the reports from the SETAs. I maintain that in order to ensure that we have stability in the governance of the SETAs, on the 1st of October, we had to have either an acting CEO with a substantive process to appoint a proper CEO put in place, or what the other SETAs have done, which is to recommend that we further appoint the SETA, the CEOs who were incumbent in those positions. And I think if the challenge is, or rather the test of whether the accounting authorities acted appropriately or not, I suppose it's not a test that belongs here. You can, Honorable Lonzi, feel free to ask the accounting authorities for the records of those meetings. But I think that based on what was required at the time, that there is no collapse of governance in all the SETAs. On the 1st of October, when that time came, the accounting authorities did what they had to do. How they did that, there is no prescription in terms of either my directive or in terms of the law. But I'm confident that the the accounting authorities followed what is required of them in taking the decision and in making the recommendation that they did to me on the 30th of September.
No, thank you, Minister. And we're on the same page on this. That's why I said I hope Chair is blocking my time, because I don't know what your leader of skills development is talking about. We agree that there are two separate processes here. There's a process where there's an acting CEO, where the AA wants to go on a substantive advert. There's a process of then reappointing the current CEO. I am saying there was no due process which was followed in the AA's getting a name to recommend to you as minister. And I've demonstrated that in just one example to say it's simply unthinkable and illogical to suggest that you can send an AA a letter today and say to them, give me a name of a CEO tomorrow. Worse, if the AA is new, and then we must believe that there was a transparent process followed in the appointment of that particular CEO. So I don't want to go back to that discussion, because we've already
essentially
debated
you're
it.
suggesting that they were not lawful. That's the transparency test which you
Yes.
got the Advovo here to tell us about. You are suggesting that they were not lawful, that they were not rational, that they were not ethical, and I forgot.
Absolutely.
And all
That's
of that.
what I'm
Well, I
suggesting.
mean,
And I'm saying we've had that debate, and I was moving on to a new topic now.
well, if
before.
it's a debate, then
Yeah.
that's fine.
Well, I'm making that
Okay.
claim, and I'll advance it, and I won't rest until I take. There is no way that a rational decision, a transparent decision, a reasonable decision can be taken by a new board today and give a minister a name of a CEO that must have a further term of 5 years tomorrow. I don't believe that a rational decision can be taken in that light. But we've already spent about 15 or 18 minutes of that. I now want to go to your own reasoning. You are saying to us, and it's what I was saying earlier on, that the AAs, you instructed them to make this recommendation to you by the 30th of September. You then discover on the 6th of October that the recommendation they made to you was essentially unlawful. Am I correct in understanding you?
Can you repeat that?
And you wrote to them on the 29th of September. You gave them an instruction. They then fulfilled that instruction, inverted commas, by the 30th.
Yeah.
You then discover as minister on the 6th of October, at least that's when you write back to them, that actually what you did is not what I asked you to do. What you did is unlawful.
Yes.
You agree with me?
Okay, and this is, I think, in the case of just two of the SETAs, which have recommended that, well, I think there's more, I'll just have to get, but there were SETAs which had recommended the incumbent CEO for acting. And I think if my memory serves me well, we can verify this. I think that included the ETDP SETA, CATH SETA, Food and Bev SETA, probably one or more other SETAs, which had recommended the incumbent CEOs as part of the three names.
Apologies, Minister. Again, it's because of time. You've already explained that context to us.
Yeah.
I am saying you give a SETA an instruction on the 29th of September.
They didn't follow the directive
And
yet.
therefore, their decision was unlawful. Because your letter says to them, I wish to clarify that this approach is not consistent with the provisions in the Skill Development Act,
Yes.
read together with regulations. Therefore, what those SETAs did by the 30th of September, me and you agreed was unlawful.
Yes.
It was unlawful. Then you write back to them on the 6th of September and say, guys, what you did by the 30th of September was unlawful because you didn't follow the act. They then submit, now they do a lawful process, in inverted commas, by the 10th of October. Would you agree with me that that unlawful decision they took by the 30th of September, it falls away, and it's only the decision of the 10th of October that stands, because they would have followed the Skill Development Act on the 10th of October?
I don't agree with you.
Why don't you agree with me?
No, because so the point I was making on the 6th of October was that I acknowledge the intention of the Accounting Authority in following the spirit and letter of the Skills Development Act, But unfortunately, your response is not in line with my directive. So in continuation of the spirit and letter which you were following, I advise you to do the following things. And so in my mind, the process that was started on the 30th of September is continuing based on them following my clarification of
What
they
is
need to do on the
important
6th
here,
of
Minister, are not your directives. What is important here is whether or not the accounting authorities are following the Skills Development Act. And the reality is that by the 30th of September, these accounting authorities did not follow the Skills Development Act.
Which accounting authority?
The two
Yes.
that would have sent you
Yes.
names to extend and you
Yes.
corrected them.
Yes.
Well, you are saying it's two. We could discover later that it's more than that. But I'm moving with two because that's what you're saying
well,
to us.
I actually mentioned 3 and I said it could be more.
So,
Yeah.
exactly. So those ones, by the 30th of September, they did not follow the Skills Development Act in that particular decision. We agree with that.
Yes.
They took an unlawful decision. Therefore, the following day, these CEOs have ceased to have a relationship with these AAs. They no longer have a legal relationship because the contract has lapsed.
Well, that's your interpretation, because my contention is that on the 30th of September, when all the accounting authorities sat to consider my directive, all of the people that they had to consider, for either recommendation for acting or for appointment, still had active contracts with the SETA.
No, I understand that and I agree with you. I'm saying the fact of the matter is not my interpretation. The contract of the CEOs ends on the 30th of September. It ends.
Yes,
The
yes,
following
but-
day, they are no longer CEO.
Yes, but
that's why you would have given them an instruction that please follow the Skills Development Act and recommend to me by the 30th of September when these people are still CEOs. And then it so happens that these people, they then take an unlawful decision by the 30th of September. You only ratify that decision on the 6th of October. They then go and take the so-called correct decision by the 10th of October. What we are putting to you, and maybe it's one of my closing remarks, is that by the time they recommended to you, the CEO no longer had a legal relationship with the particular SETA. On top of that, by the time you concurred with the decision, the CEO never had a relationship with that SETA. You appointed an unemployed CEO who was sitting at home. It's like changing a flight ticket when the flight has already taken off, Minister. The flight is gone, it's going to Joburg, and you want to change the flight ticket. And that's the argument that we're making to you, Minister. So, I don't know if you want to respond to that, but I don't know how much time I have left, Chair. If I've got little time, I just want to make closing remarks, and then I'll end there.
Well, I think I've made the point, and I think Honorable Lonzi has made his point, and I maintain that firstly, my action of the 29th of September, asking the accounting authorities to nominate someone to occupy the CEO position were lawful. Their actions on the 30th of September were lawful, and those who did not follow the directive were reminded of what the directive were on the 6th of October, and they subsequently complied with what the directive was. And for me, there's no interruption in the application of the law up to the point when I concurred with the recommendations. What the Act requires, and I'm going to emphasize this more than I have to, is that the recommendation for the reappointment had to be made at a particular point. There is no requirement. I mean, I think so what does it mean? If the recommendation is made on the 30th of September, something else happens, just as it happens in this case, does that necessarily mean that the people who are being considered either for acting in those positions or for substantive positions that that they should be prejudiced? I believe that as per the required by the law, I believe that I've acted as per the requirement, and similarly did the accounting authorities. And I think if you've indicated that you will ask the accounting authorities to furnish you with the minutes to satisfy yourself if they've really applied their mind. And I think the same applies with the rest of the other processes.
Thank you, Chair. In closing, Chair, would like to request that the department, because the department performs oversight over the AAs, the department must submit the minutes of those board meetings which took place to take the decision that current CEOs, the 8 CEOs or 9, must be reappointed for a further term of 5 years, because we believe that that decision was unlawful. We believe that that decision did not follow a due process. We believe that that decision did not follow a transparent process. The minister even admits before this parliament, says, I didn't have to be transparent. Those were his words. We can go back to hindsight. He
No,
says,
I don't think
we'll
that's
go
true.
back to
I don't
hindsight.
think that that's true.
I'll record the video
Yes,
and send it
please.
to you.
Yeah.
The minister says, I'm not required to be transparent. And it's a reflection of what the department did, because the extension of the current CEO's terms of office for an additional term of 5 years was not transparent. There was no public consultation, there was no advert, there was no shortlisting process, there was no
There's no
recruitment process,
requirement,
there was
Chairperson, for us to
none of
conduct
that.
any public consultation.
And what we are
as,
seeing,
Honourable
Chair,
Lonzi's
I'm making my,
indicate. In fact, all the requirements you mentioned are not required.
I'm making my
We've
closing
met
remarks.
all the requirements
I'm making
as
my
per the
closing
law.
remarks. The minister is going to have to calm himself down. The decision that the department and the minister took was unlawful, and we are going to follow the matter up, because there is no South African who can believe that a new board that has just been appointed can be given an instruction by the minister to recommend a CEO to be appointed for 5 years. We're not talking about an acting CEO here. We're talking about someone who's going to be a CEO for 5 years. And this board takes this decision in one meeting in less than 24 hours. Not only that, by the time the minister sends the appointment letters, the CEOs no longer have a legal relationship with the SETA in question. Even that is unlawful. And Chair, that's why we request the minutes of those particular meetings. We request the letters, because in your letter that you had sent to the minister, Chair, you asked for this legal opinion. It was not given to you. You asked for letters that were signed by the minister. They were not given to you. The minister says he has never seen a legal opinion. The department, the legal, says, no, there is a legal opinion here. The minister says, I've not seen the legal opinion, but I believe that I acted consistently with the legal opinion. How do you know you acted consistently with a document that you've never set your eyes on? So can we please get those particular documents as well? And I can tell you now, Chair, what we tried to fix with the former administration is re-manifesting itself now. I don't understand why the minister can't just say, guys, even if he wants to bring back these current CEOs, why can't he just subject them in a competitive process, in a transparent process, even if they come back? Why can't they apply like every other South African, be given an opportunity, open it up? Why must they be appointed at night in less than 24 hours and they are given an additional 5 years without a transparent process? We submit. Thank you, Chair.
Thank you, Chairperson. Firstly, what we must indicate is that the practice of appointing incumbent on the basis of their performance is not new. That it is practice, it has happened in the public service. This is also not the first time that CEOs of SETAs were incumbent, their contracts were renewed, and that the same process that have followed in this regard is the same process that previous executive authorities have followed in appointing, CEOs, and that there's nothing untowards, and that if the competence of the people in question is in question, that process can be unfolded. And I think as it relates to some of the documents that Honourable Lonzi is asking for, we will look at specifically what those documents are, and furnish those. But I'd like to correct also certain misstatements which are attributed to me in this meeting. Firstly, I said that I have never asked for legal advice on this matter. And I've stated the reasons why I've never asked for legal advice on this matter. And I place that on the record. Secondly, if we did not take the action which we took, under the circumstance which we took this action, there would have been collapse. And I think that we were within, our right, within the law, to take this decision. It has got nothing to do with lack of transparency. It has got nothing to do with, being, influenced in any other way. I believe that this decision can stand the test of law. And just as much as you believe that we, might have acted wrongly, I believe that we followed the law in its spirit and letter. Thank you, Chairperson.
No, thanks, Chair. I had my hand up before you, sorry. Okay. No, Chair, maybe mine is not necessarily to reiterate what Honorable Lonzi has been advocating for, but maybe just to deposit on the same point. Minister, for the mere fact that you concede that there are some SETAs that have done mistakes, at least 3, and there could be more, that's your words, in terms of the process. Honorable Lonzi was registering the fact that that 24-hour period that we had given the new accounting authorities was not adequate to do due diligence, transparency, and ethical exercise in terms of ensuring that the final product, being definitely an extended 5-year term, could have not been reached in 24 hours if, obviously, by looking at the performance, you're looking at a performance of a person that would have served 5 years, and you're doing that in a span of 24 hours to give another 5 years. So that is his point of argument on this particular matter, which we agree. So for you then to say others would have made mistakes, but you believe that that 24 hours was adequate, is certainly what we do not agree on. I think I just want to emphasize that particular point as I gathered it. Thank you, Chair.
Yeah, thank you, Chair. Yeah, it's on the same point of the phenomenon of the extension of a term of office for incumbents not being a new thing. I agree with you, it's not a new thing of extending based on satisfactory performance. But you can't make that argument for in-SETA and MICT-SETA on audit outcomes alone. In-SETA for the financial years 2023, 2022, 2023, they had a qualified audit. 2023, 2024, qualified audit. 2024, 2025, qualified audit. The CEO there cannot be a person that, based on their performance within 24 hours, could have been considered to have had satisfactory performance. That is number one. Number two and last, MICT-SETA. In 2022, 2023, they had a clean audit. They had a clean audit in 2023 and 2024. And then come 2024, 2025, their audit outcome has findings, a regression. And even there, the principle of a consideration of an incumbent on the basis of good performance falls flat. And again, those recommendations of within that 24 hours would not have afforded the board time to then consider properly. And then just finally, you make a point, Minister, that whether the process they followed or not is not something that must be scrutinized here. But I put it to you in finality that your appointment is based on your scrutiny of the recommendations, and your scrutiny beyond what is given to you is the process that was followed. And if you failed to scrutinize if a process made sense or not, then it means you must concede that your conclusion on recommendations was also flawed. That's that. Thank you.
Yeah, I mean, safe to repeat myself, Chairperson. I don't know what else I can say to persuade the members. But maybe in addition, I wouldn't want to get into the merits or demerits of each of the CEOs and all of that. But safe to say that some of the SETAs, when responding to the recommendations by the accounting authorities, I've actually instructed them to follow through on some of the issues that have been raised relating to those CEOs. Thank you, Chairperson.
Honorable Ngubane.
Yeah, I think, thank you very much, Chair. Minister, you know, I've been sitting here, I'm at pain listening to you and your team. I think there is an injustice that your team is doing at yourself. I don't know whether is it yourself that you are doing this to yourself or is it your team. But I'm at pain to listening to all this in conversation. Because some of the things, as I'm sitting here, I wish I could come and sit on that side and assist you to reply to all these colleagues of mine. They're asking questions because they need proper answers. That even I can come and sit there, I can give it to all of them, but they are not coming from your team, Minister. Simple answers. Let me take one example before I move to my own question. The one asked by Honorable Kakao, the answer is simple to say, on the extension of the contract, or the extension of the CEO's appointment, the clean audit or the non-clean audit is not part of what is required. Mostly all the CEO, on their last day, they had performances of up 90%, almost all of them. And some of them, it's something that we always argue, Chair, that please tighten up on the performance. If people are getting 90%, it means it's easy to do this job. So mostly are getting, on all their performance contract, all of them until to the last quarter, they got 90%. So all these things that colleagues are asking, they could be answered by a competent team, and it is not there. That's my only concern, Minister. I'm not going to delve much on these things of SETA CEO. Chair, is Karen gone? Are we still probing Karen as well? Yes. Yeah, I wanted to ask Karen questions before I come to the Minister. That's a comment, Minister. It doesn't need answers. I just want to ask some few questions to Karen before I then come and end with you. Karen, are you online?
I am still here.
Oh, thank you. There's 3 questions I wanted to ask from you. With the presentation you did, thank you very much for the presentation. With the presentation you did, which is excellent, it's got the references. It was good to see it being presented. Did you try to engage the CEO on your working challenges with him? With the challenges you were experiencing with the CEO, did you ever try to table them before the board or its committee? If so, did you raise those issues to sit with your subordinate one-on-one and to say, these are challenges I have with you, and even report all those challenges to the board? If that's what you did, when did you do that?
Thank you for the question. Yes, I did raise issues with the acting CEO, also with members of the board. When I will have to just go back on dates. Do you want them now, or do you want me to just give you to them in writing?
Are they long? If they're long, I think you can give it in writing. I thought it was just going to be few of them, but if they are long, then you can give them in writing.
Okay, I'll give them to you in writing, sir.
Okay, second question. If I've listened clearly in your presentation, in your opinion, the acting CEO was not performing or not taking instructions according to what I've heard, if I've heard you clearly. So there was a lack in your subordinate to take instructions and performing. Did you brought that to the board so that the board can then look at this CEO who's not performing and remove him or take some certain action, because he's acting as we speak. He can be sent back to the, what you call that, NYDA. Did you look into that? Because this is just an acting CEO. Did you brought that to the board to say, I have a challenges here, and then let's act on this, because the person the acting CEO is not even appointed, is just acting, was recommended from the NYDA.
So the presentation didn't speak directly to the acting CEO. The acting CEO has been appointed by the administrator as the Chief Financial Officer of NSFAS. So he didn't come, he was there actually the same day before we started, permanently appointed as the Chief Financial Officer of NSFAS. He was no longer involved with the NYDA. So, yeah, I didn't really speak directly about the acting CEO in my presentation. But if I had any issues, they were raised to the board.
Oh, but Karen, according to my understanding of corporate governance, a person who reports to the board chairperson is the CEO. If you're saying on your presentation, there was people who were not taking instructions, they were not taking my call, there were no performance, I'm assuming that your subordinate was the one doing that. Because according to my understanding, the person who looks after or who makes a person account, a board chairperson makes the CEO account to him on behalf of the board.
Yes, the CEO to the entire board, but there were also instances where other executives were necessarily involved. So it's not directed directly to the acting CEO at all.
So you didn't have a problem with the current acting CEO's performance, or not taking instructions, or disrespecting you, or maybe bullying didn't came from, it came from within board members or not your subordinate?
It's very difficult to really say well, how I perceived him, you know, versus, and like I said in my slides, somebody, one person's effect is somebody else's hero. So it's my own perception, right? So, and it's again not just directed towards the acting CEO. That's why I didn't mention names specifically there.
Okay, because on my assumption, if you are a board chairperson, and then there are people who are bullying you, who are disrespecting you, who are not taking instructions, my assumption was that it's your subordinate that you're supposed to work with it correctly. But if you say it's not the CEO, let me move to my third question. Your resignation, we started to read from the media. Did you send it to the media, or when it was sent to the minister, it got leaked to the media? Who leaked it to the media? Or
I don't know who leaked it to the media. I sent it to the office of the minister only, and then before, I think even before the minister got the hold of the email, it was in the media already. So I don't know.
You don't know who leaked it?
But it wasn't
probably I
myself.
want to ask the minister from there onwards. You don't know. On your side, nothing was sent to the media?
No, I sent a statement to the media saying nothing.
Okay, all right. My last question. Okay, no, I think I'm fine, Karen. Thank you very much. Ne?
Okay, thank you.
Thank you. Okay, the minister, you didn't leak Karen's resignation letter to the media. Can I confirm that?
No.
Okay. All right. No, he said it's sure. Yeah, I think, Minister, from my side, with the SETAs, unfortunately, I've got huge experience on these things. I wouldn't want. There are some questions I want to ask. There were lines on 2CO that says, it says subject to AA. I don't know what does it say. Let me quickly read it correctly so that I can quote what I'm talking about. It says with condition on the incoming AA. With those two CEOs, what is the condition on the incoming AA that is still outstanding? Because my understanding, the process of fully fledged appointing a new CEO, that's why there is this 6 months acting. If you didn't do, if your predecessor didn't do injustice to you, you'll have that 6 months of advertising and doing all the processes, recruitment, interviewing. But you came, that 6 months was already been eaten up by whatever process that was happening before. So now you had this period that is small that you have to rush to comply. The process of advertising and recommendation is different, especially on the AA for recommending the extension. That one we understand. So what I would like to know, with these two, which says something is still outstanding to the AA, what is it outstanding? And then the other one, for those...
Specifically which two, Honorable Member?
Yeah, there is one on your presentation. Let me quickly read to it. It's in SETA and FACET. It says, with condition on the incoming AA. What are those conditions?
Okay. So, with regard to both SETAs, there were issues that were outstanding, which may not necessarily have interfered with the appointment of the CEOs substantively, but which I, as the minister, do not have the power to probe, which could only require a competent accounting authority, to probe. So I've asked the accounting authorities, to probe those matters and give me a report. Let me give you an example. So the CEO of FACET, I think there was a big dispute when the accounting authority's term lapsed, that they had asked for concurrence from the then minister to take disciplinary action. And what the then minister did was, instead of concurring, she then advised that the new accounting authority will have to take up that matter. So that's the context. So they will have to take up that matter and then give me a report in that regard.
So which means these two were not recommended for
No, they were recommended. They were recommended for reappointment. They were recommended for further appointment by the accounting authority. And as I said, that I then asked them, based on their recommendations, to then advise me on how they're dealing with those specific matters.
Okay, because I still don't get with condition on the incoming AA. With what is those conditions?
So the CEOs have been appointed substantively. So they are CEOs of those SETAs. What the accounting authority is required to do is to look into the matters that have been raised about the CEOs. For instance, like I said, with FACET, I think they Nehau at FACET even wrote to the chair, bringing to the chair's attention, which he brought to my attention, the issues that related to the to the CEO of FACET. So those matters have been referred.
That's the issue of the FACET where the previous board.
With regards to the insurance SETA, were inundated with some inquiries from one of the training providers, which we've asked the accounting authorities to handle.
Okay, now it's clear that it's just matters that are outstanding, but the extension for the next 5 years was done. It's just matters that needs to be attended by the incoming.
So they'll advise how
CEO.
they're handling those matters.
Okay, all right. And then these ones have been appointed. The rest of the others, what's the status of them? If they haven't been appointed now, after 30th of September, ne? Have the CEOs went and stay home now, or what's the status of the rest that hasn't been recommended by the AA, or went through a process of advert, recruitment, interview, and all? Where are they? Have they went, sit home, and
know.
3 recommendations?
I don't know.
We'll say CFO recommended. What's the status of the rest?
I don't know. I don't know where they are. You're saying what's their status?
Are they still the CEOs in those other SETAs or not yet? Not.
Okay. Okay, let me just explain what's happening. So we have 21 SETAs. 3 SETAs are under administration. 1 SETA was not, I think Transport, Education and Training Authority SETA. The SETA's CO is under a different contract regime, so the accounting authority was not required to act in any way. There are, I think, 8 or 9 SETAs which the accounting authorities have recommended that we make further appointment of the incumbents. And then the rest of the other SETAs, there were recommendations for us to appoint acting CEOs because the accounting authorities wanted to go through the 6 months process. They were obviously not, I don't know, yeah.
Yeah, I think that's where I'm asking, Minister, that those ones where the accounting authority recommended either the COO, CFO, it means the CEOs, because remember their contract ended. It means they went and their contract has been terminated.
All the CEOs of all the SETAs, their contracts were ending on the 30th of September, except those CEOs where the accounting authority, there's not even an exception. So from the 1st of October, there were completely new appointments, either substantively or on an acting basis.
His question, Minister, is that you had 21 SETAs
Yes.
minus 4.
Yes.
So you had 17 SETAs,
Yes.
SETA CEOs.
Yeah.
Out of this 17, you're saying 8 or 9 are recommended for 5 years. So it means you have 7 SETA CEOs that so far are unaccounted. So he's asking, out of these 7, how many were recommended as part of the 6 months? Not the 5 years. As part of the 6 months, and how many were not recommended at all? That's what he's asking on this question.
Okay, so of those where they're acting CEOs, is that the question?
Yeah.
So how many were not recommended? Well, where there's acting CEOs, it means that there was no, where there's an acting CEO, I think it means the SETA did not recommend, the incumbent, and in instances where, I think let me leave it at that because
Okay, so the answer is that on this 7, all of them did not come back. That's what it means. Okay. Is that,
it means
That's the
they're
question, Chair, because even 6 months doesn't come. Remember, 6 months has been exhausted already. It doesn't repeat twice, according to my understanding. 6 months was done previously by
Yes,
the...
for the
So it
incumbent-
doesn't count
Yes.
anymore, it's finished.
Yes, for the incumbents, the 6 months ended on the 30th of September.
okay.
Yeah. No, thanks, Chair. Sorry, Nopal. I think it's a follow-up on a question that you've raised. I wanted to just find out from the Minister the issues that would have now surfaced around the 2 CEOs, I think you mentioned, which the condition or the outstanding issues that the accounting authorities must look into. When did those issues surface? Before they were appointed or immediately after they are appointed? Just so that we know if you ended up taking people that have outstanding issues and still appointed them for the accounting authority to deal with those issues later. So when did those issues surface?
To be fair to him, he has already answered that question. He said these were the issues that were ventilated by the previous board, but they were not concluded by the previous board. Now, he said the new board recommended him to appoint them. And then in his appointment, he said, okay, I take your recommendation, but please look into this matter. No, Quebec. No, there was no.
Yeah, no, I think you are right, Chairperson. I will explain to my youth league the rest. Yeah. You tendal. Yeah, I think I will explain. I understand what the minister is saying. No, I think other than that, Minister, from my side, again, I will emphasize this thing. These are easy explanation. For the moment, Mina, Chair, I saw a letter from outer that says the minister is wrong. What does Gambit say? It says the minister has flouted appointment. I knew for sure that there was something wrong from there. I hate to say it, unfortunately, you tried to cover yourself. My challenge here, Minister, I'm going to repeat again. The incompetent team you are surrounding yourself will fail to explain simple things. That's my challenge that I have around yourself. There's nothing wrong with these things, but the team that you are surrounding yourself is failing to explain a simple thing. Thank you, Chair. I think that's all from my side that I wanted to ask. If the minister wants to comment, I'm fine, but that was just my input.
On a lighter note, Chair,
Well, I think-
the MK must go caucus. Because Unopala, Nomsezana are saying two different things.
No, we are not saying two different things. You don't understand it. I can.
It's okay.
I want a clarity on something,
Hold on.
which I can clarify from here. Yeah.
Yeah, let's not fight. Yeah. Honorable Governor, I'll give you Honorable Governor. Are you tired, colleagues? Are you tired? No, we're not. So why don't you allow Honorable Governor to speak? No, please, you guys, Honorable Governor, please come through.
All right, sorry, Chair.
Yeah.
Thank you. Chair, I will not be long. Greetings to yourself, honorable members, Mphathiswa neThimba lakho. I think I will submit more of my questions and clarities. I will write them, Chair, but I will have to just ask or advise on 2 or 3 matters. Maybe one, let me first go to the former chairperson's presentation. Is she still up there? Oh, okay. One, I think presenting her challenges or difficulties in the department and not being specific is dull, is not going to assist the department to improve, because we do not know how to follow the allegations she has made. She used big terms and she even referenced them today, but they are not direct to anyone. So we do not even know where to direct questions. We do not know where to find findings. We do not know how to assist so that the next person who comes does not encounter the same challenges she has encountered in the department. Maybe let's beg her to at least be precise on what took place or what transpired, because what she has submitted is very quiet for us to even interrogate. That's why I listened and I asked, why is she given an opportunity to present? Because I didn't know what are we going to say to this presentation, because it's very quiet for my liking. I will speak about two things that I have noted while seated here, Chair. I'm done with the chairperson. We just beg that she writes proper allegations that are directed to someone, because she was disrespected by someone, she was not listened by someone, she was hurt in the process by someone, so she must not generalize. We can't help the situation if it's general. Mphathiswa and the department, I note a gap in our policies. I see a gap because you listen after the interactions that have been taking place. The law or the act is very quiet. What then happens after the 30th of September? It becomes very silent on that. Then how do we judge whether it was correct or incorrect? Because it says nothing. This is where we come in as lawmakers. We need to amend these acts so that they speak into after the 30th or the closing date. Because we can't sit in the room and accuse one another who did right and who didn't, whereas the law doesn't say anything about what then happens after the 30th. So I'm putting this in the department that at least let's work on the amendments of the policy and the act so that it speaks about what then happens after the recommendation or the dates have been closed. Mphathiswa, we are not happy on the issue of diversity. Maybe also, that's why I'm saying I'm only going to speak about the gaps now. The law must be very precise that a certain percentage must go to young people. It must not be quiet, because we know that your hearts are not where young people are. We have observed every appointment does not have young people. So literally it says, when you'll think around your regime and your age group. You think around about the people that you grew up with and you went to school with. So definitely you can never think of SETA because you did not go to school with SETA. So the law must be very clear on saying, on appointments of chairpersons and CEOs, 30% or 40% must be young people, people living with disability, and LGBTIQ plus people. It must be, and the minority group, it must be very clear. Because if we are going to wait on your thinking, it's going to deprive us, Chair. No young people will ever form part of these decision-making portfolios. No young people will sit there. Because I tell you now, if you look at those elders that were appointed, it's very old people. And young people were there. Young people qualify. Young people can actually take better decisions than some old guys in this room that I've observed today. They can interact much better. So why not give them an opportunity rather than sustaining livelihoods of old people who are supposed to be doing agriculture at home and assisting our children, because they are not assisting the process. I don't want to mention names. Another thing that I would want to comment on is the issue of the DG. You know, the problem of not finding direct responses to questions that are coming from our side is the act of the DG not being in committee meetings. Mphathiswa, u-DG uyaphila xa kufuneke eye kuma-events. You know, when you're going to these ceremonies that you attend, the DG is there. But once kuthiwa he needs to come to a committee, we get a sick note. I think it's a coincidence or something. Maybe bayamthakatha or chairperson, I wouldn't know. But it's a bad coincidence that we really need to look into. Even though I was watching very close today, the acting DG, there is something that I loved that he does not do, that the DG does. Xa ihleli pha, uhleba imini yonke u-DG. So umanzini uyihlalele lapha ubambile indawo yakhe uyithulele uminister uyayiphendulela. Even the responses that you gave into the house, we can actually say they come within your knowledge. Because uDG xa ihleli pha will whisper throughout the session from 10 till 10, he's whispering wrong recommendations and responses to the person that he should be assisting. Ndifuna ukusondela ke ku-Honorable Ngubane that we might think there is a problem, maybe, okanye this department is bewitched. But I solely believe that if those comrades that side can strengthen their socks in assisting in responses and doing their work, we might not have a problem. The policies, Minister, do not talk to time frames. We are looking at the time that was given to the board to recommend, but now we need policies, acts, regulations that will speak to time frames. Because we might not have the problem in the previous administrations. But now we see that South Africans are interested in finding proper time frames so that the adequate or the diligence that is supposed to be done in appointments and recommendations is done properly through time frames. Then it then says we must go to our policies and regulations and amend them so that when you come and respond, we will question you on not working towards the policies and regulations. But you being seated there now, we notice that you have not dealt or you have not offended any act in terms of law, because the law stops and then you have to continue on your own, and the law does not assist you to further take actions. And maybe I need to beg your people, Minister. It is not always important to respond, nor to talk. Sometimes you can sit in a room and say nothing, it is okay, rather than to respond to something that you know of. Rather than to complicate a matter even worse. A person is given 2 ears and 1 mouth, meaning it is very important to listen than to talk. So keeping quiet is okay. You all don't have to justify things that you all don't know. You can sit there and just keep quiet. Only respond when you are asked a question. Because now you all are found in positions where you are trying to explain things that were not asked, especially not to you. You can just keep quiet and let things be. Let the person responsible for a department or a question respond. Because we have started from 5 up until going to 11, most people are answering things that they were not asked. So you are actually wasting our time. And you are ought to lie because you don't know what you are responding to. So preferable, Minister, when you come in the room where we are seated, have a caucus with your people and be very clear that who responds and who does not respond. Because they are not only making them weak, but they also making you weak because they represent your department. And when they are in tatters, that is why we have these problems we have. Maybe for landing, Chair, the questions I have, I will write them. But maybe for landing, we must emphasize on the issue of NSFAS, especially next year. beginning of the year, the NSFAS must not collapse. NSFAS must not collapse on us because it is going to be a nightmare. You were presenting the stats that have wider gaps already. So if you start now and it collapses, we are going to be a madhouse, all of us in this room. So, Chair, NSFAS must not collapse next year. Proceedings of universities, TVETs and CETs must go very smooth, and you all must work within the dates that you have presented, but mostly even fall before than to be sorry. I thank you, Chair.
No, thank you very much for the comments. Honorable Low.
There's a hand.
Oh, okay, sorry, Honorable.
He also interrupted me, Chair, when I was speaking. So I'm returning the favor. Minister, I was hoping by now your staff members would have produced you with the letter that you claim was consultation with the NSA. So I've just got one quick question, Minister. Do you still stand by your statement earlier on that on the 7th of August, you never held a consultative meeting with the National Skills Authority? Do you stand by that?
Okay, so I don't know what date you're referring to, but as it relates to the putting SETAs under administration, I have not had a physical meeting with the National Skills Authorities Board.
Now, thank you. So it means you stand by what you said. This is why I'm asking you, Minister. In your answering affidavit to the local government SETA, you say, maybe let me read, I'll read it very quickly, Chair. On 7 August 2025, I consulted with the National Skills Authority in terms of the provision of Section 15(1) of the SDA Act as amended, which clearly states, we know what it says, I won't go to that. Paragraph 89, you say, Minister, during the consultation with the NSA, the business of the day was the discussion of the investigation that was initiated by the National Treasury following the allegations from an anonymous whistleblower consistent with the principles of accountability and ethical governance in the public sector. Is this true?
And can the honorable member repeat that?
Your answering affidavit to the local government SETA, to the court, says, on the 7th of August 2025, I consulted with the National Skills Authority in terms of the provision of Section 15(1) of the SDA as amended, which clearly states, I won't read what it states, we all know what it states. Paragraph 89 then reads, during the consultation with the NSA on the 7th of August, the business of the day, and I repeat, the business of the day was the discussion of the investigation that was initiated by the National Treasury following the allegations from an anonymous whistleblower consistent with the principles of accountability and ethical governance in the public sector.
Yes. What's the point, honorable member?
You say you never had a meeting with these people of consultation.
Yes, I've never had a physical meeting with the National Skills Authority.
You had a meeting virtually?
Honorable member, I've never had a physical or virtual meeting with the
So
National
what is your
Skills
understanding
Authority.
of a business of the day?
I consulted with the National Skills Authority as it relates to the SETA in the manner in which I consulted. And I think if there's any other thing that the honorable member wants to take up, I think we
Minister, what is your understanding of saying, during the consultation with the NSA, the business of the day was the discussion of an investigation that was initiated by National Treasury? Remember, you said before this committee that you didn't have a meeting with these people. You sent them a letter, they then responded. That's not a discussion. That's correspondence. Send them a letter, but in your court papers, you say, during the consultation with the NSA, so it's something that is happening during. The business of the day was the discussion of the investigation that was initiated by the National Treasury.
What is the honorable member trying to suggest?
It means these versions can't both be true at the same time. They are mutually exclusive, Minister. It's either you're lying to Parliament or you're lying to the courts of South Africa.
Well, yeah, the facts of the matter is as I've mentioned. I have never had a physical or virtual meeting with the National Skills Authority. I'm required to consult with the National Skills Authority. There is no description as to the form of that consultation, and as far as I'm concerned, the affidavit I've deposed before the court was consistent with my recollection of those facts.
Thank you, Chair.
And I think that's
Thanks, Chair.
thanks.
I've made my point.
Yeah, I was just going to say through the minister, the consultation did take place, but as the minister says, it's not prescribed that he has to come in person. The officials of the department, acting on the instruction of the minister, consulted with the NSA. Thanks.
Chairperson, can I come in? So just for clarity, so the minister, so you guys had a meeting and the minister had sent a delegation. Like, make it make sense, because now you're saying there were officials of the department on behalf. So Hlalosa, what happened? What is the manner of consultation that the minister did? Did he pick up the phone? Did you have a video call? What happened?
All right. The Public Service Act will inform you that the department and its officials, they serve to support the minister. So a letter was received addressed to the chairperson by the minister, and on the basis
The chairperson of the NSA.
of the NSA. On the basis of that letter, the item on the consultation by the minister in respect of the taking over of the administration of the SETA's concern was then included in the agenda of the.
So the business of
So
the day
then
that the
there were-
minister is referring
so
to in the
then
court
there were-
paper is the business of that particular meeting, which the department was mandated to go to as part of service to support the minister.
Yeah, let's separate. The court papers were not involved here. So I'm just saying, then the item was placed on the agenda, then there was a presentation of the case to the NSA with all the issues involved, and there was a discussion, a resolution was taken, and an advice to the minister was then written.
Okay, Mr. Kuzwa, what act is this? Guides you here?
The Skills Development Act, sir.
Yeah, which act, which section?
Section 15.
Can you open it there?
I
It's
have
section
it.
15(1).
Section 15(1).
Yeah. What does it say?
The minister may, after consultation with the National Skills Authority and the SETA in question, direct the Director General to appoint an administrator to take over the administration of a SETA or to perform the functions of a SETA. If the SETA fails to perform its functions,
Okay,
Okay,
those
it's fine.
ones. But the first line there, what does it say?
the minister may, after consultation with
Hold
the
on.
National Skills
Does
Authority.
it say or delegated per se?
No, it does not say.
Yeah, you see, that's why I don't understand why sometimes that question was not asked. But we enter and give answers that I honestly, I don't understand. Because all along here, we're having a discussion about what the Act says. Now, what you have just said, trying to explain, you are in fact saying yourself as the NSA may have sat in an illegal or irregular meeting. Because it's not what the Act says. That 15.1 says the minister and does not say or delegated. So somebody who argues can go and argue and say, the NSA sat in an irregular meeting. And discussed the contents of, because the minister had responded and said, I had consulted, I'd written.
Yeah.
You are saying, okay, Honorable Lonzi says, no, that's not entirely true, there's this part. You say, no, indeed that meeting took place, but we had officials of the department. No, even if it's delegated by the minister, the Act does not prescribe, because all along we've been having a discussion about what the Act prescribes and what it does not. So you are now creating a problem for you, and this is what Honorable Ngubane was saying, that there are certain things that I don't know how you colleagues want to explain them. Because the Act, that's why I said read it. Because you are saying he consulted through the department. If the Act wanted to have that provision, it would have included it. It does not include it. But you want to mention it when, in fact, it was not even asked. Minister, you wanted to say something?
No. Yeah, I thought the matter has been closed with Honorable Lonzi, because I thought the question is whether have I consulted or not, yeah. So, thank you, Chair.
No, it was closed until that the Kuzwa
Chair,
opened.
sorry to do this, because and you always make this point, that people answer things that they were not asked, and they end up forcing us into another discussion. So, for the record, because he's totally misrepresented what I was talking about, here, I'm not talking about the department. Once the minister says I in an affidavit, he is taking personal accountability. If the minister says on the 7th of August, I consulted with the NSA, and the business of the day of that consult, he's speaking about himself. He would have, if he wanted to say, I sent department officials to go and consult on my behalf, he would have said that in the affidavit. So we're not dealing with that. We're dealing with the minister. In court, he says, I consulted, but in parliament, he says, I sent a letter and the NSA responded. So I just wanted to clarify that aspect, Chair.
Okay. Honorable Law.
No, thanks, Chair. The students are waiting for answers from NASFAS. We are just on the CEOs, which are quite critical, and I think it's not fair that if we are going to focus, you can sit down, CEO. Yes. First and foremost, I want to welcome the presentation by the former chair who could have resigned from the board. And I hope she could have done it also to the board, also to give them a proper, well sent off lecture that I think it has educated us well onto the systems and structures. Let us welcome it firstly. And secondly, I would want to, I don't know if she's still there. I wanted to ask a few questions, Chair. The first question I want to ask is that, has she ever written a letter to the minister, or has she ever written a letter alleging that the CEO, the acting CEO, is a problem in the board, or there are issues with the acting CEO? I'm basing this because the presentation did not have any other person that she could have apportioned it to. So I wanted clarity from there. That's my first question. Thanks.
Just repeat the question, please.
My question is that, have you ever written a letter of complaint against the CEO? Have you ever had an issue against the CEO? Because in your presentation, you did not apportion anyone to be a problem, but you were generalizing systematic issues that you think were deficiencies that could have assisted, if you could have dealt with through your proposals, that you could have cited strongly so.
Yes, no, I didn't in my presentation name any name specifically. I did write the minister a letter on various governance concerns. I didn't blame any specific person, like you would have also said earlier today. I just raised the issues that, as I did with you today, that I felt that needed to be looked into by him.
Dog? Dog?
Yes.
Yes, are you done?
Yes.
All right, I wanted to, okay, Minister, have you received a letter from the dog that had a complaint directly about the CEO or the NEDDG of the branch that NSFAS fall off? I want to get to this because dog is saying she never complained of any individual, but I want to get it from you because the letter was written to you. Minister, have you received a letter from doctor before that she could have resigned that that was directly saying that the CEO and the DDG or CEO or whoever are a problem with regard to that? Or did the letter just say in general, inciting all of those issues, these are the issues that we're confronted with? I want to get it from you.
Yeah. I think, like I said earlier, I think on the Thursday before the chairperson's resignation, she wrote me a letter detailing some issues that she was concerned about. We can copy the, with the permission of the former chairperson, we can copy the committee that letter. And I immediately asked for a meeting with her. Then there was the board meeting, I think, and then on the Sunday after that board meeting, before our meeting, the chair then sent a letter of resignation. Yeah, so there was not sufficient time between me handling the issues that she's raised with me and her resignation, which was, I think, about 3 or 4 days. And at the time, I don't think I was even...
In my question, I wanted to check, did she single out the CEO or any other DDG as part of the systematic issues or problem that are confronting the entity? Or did she generalize like she's saying now? That's what I'm trying to get.
Yeah, I don't remember any specific mention of individuals. Yeah, but I stand corrected.
No, you can therefore share the letter with me. My last question to the former doctor, I would also want to check.
She's former chairperson.
Former chair. Sorry. Former chair. She's still a doctor. Yes, she's still a doctor. Yeah.
Should we worry about the quality of your questions?
No. What becomes quite important, I would also want to ask a last question to you and then focus on NSFAS chair, because I think it is quite important that we deal with, we give a fair chance for students to understand the state of readiness of National Student Skills Fund, because most of the members would have dealt with issues of the appointments of the SETAs. I'll submit my questions on that written to the secretary so that the minister must respond directly. And then I think I should deal with issues of NSFAS, because I think it's only fair that we get to know and understand the details as to how ready we are. And CEO, I want to start with a question that says that as NSFAS made its commitment to finalize all outstanding student allowance payments for the 2024-25 academic years by 31st of May 2025, as you could have said, so that we're able to start it from there.
Thanks, Honorable Law. I think you mean by 30th November, right? Not 31st
Yes,
May.
yes.
Yes. We are on track to complete all outstanding disbursements. It's what we call our mop-up payment. So it's all of the payments that we would have not completed in the normal scheduled 10-month disbursement. That is scheduled for this Friday, and we are on track to complete that.
Okay, thanks. The other question I want to pose is quite significant that I think Honorable Khaba could have touched it. And then I would want to check because my worry is that there's an outcry of those who are out of campus as providers, whom they either accused of harming our female learner students whom are not paying due to allowances, and it's either they are removing students out of their accommodations. So I would want to know what steps has NSFAS taken to ensure that timely payment of outstanding claims from private accommodation providers are being done in this particular academic year. And then if so, we have not yet done, how many claims remain unpaid, and what is the total of these outstanding payments?
Thanks, Honorable Law. So when we would have done the presentation, I think we would have indicated that we have about 48 million rand in outstanding accommodation disbursements to accommodation providers, which we intend to settle, as I would have indicated in the previous response, by this coming Friday. We don't have more than 1,000 students which need allowance mop-ups that need to be done, and that's on the TVET side, which again we intend to conclude before the end of November, which I think then would bring the 2025 academic year disbursements to its natural conclusion. What we are focused on is strict adherence to the academic calendar for 2026, which means strict receipt of registration data, and I think in the previous presentation we would have interrogated that. Because should we receive the right data for the correct students on time, it will ensure that as an NSFAS we can make timely disbursements to students between February and October, as is our planned disbursement schedule. And we can not put any student in a position where they are required to be transactional in any means because they've not received the NSFAS allowance. Secondly, to prevent the issues that we've had in student accommodation, we are pre-planning. We're doing a pre-assessment of all the available beds that we have per campus versus the anticipated registrations to illustrate where we have enough capacity to accommodate students in student accommodation. Where we do not have enough student accommodation, we will encourage, if possible, students to rather opt for the transport allowance, if that is feasible. Obviously, if they live 400 kilometers away, the transport allowance doesn't become feasible. But if students are required to reside in unaccredited accommodation, we will be honest and transparent about that there. The second thing is that we intend deploying full-time capacity to institutions of higher learning to support the placement of students in student accommodation, to ensure that they are placed in places which are safe, accredited, that the lease agreement is signed on time, so that accommodation providers can also be paid consistently on time throughout the academic year. So I think that is our intention that we intend to execute on. And of course, that is the public commitment that we are making. And we know the portfolio committee will hold us accountable on those commitments.
Thanks very much. The other concerning part of the student is that we would want to check what systems or technologies have been introduced to detect or prevent ghost student claims, because it has been an issue of the past, and I want to know, have we ever had to, at this particular opportunity, you being an acting CEO, have we ever met an issue of ghost students? And if there are any ghost students, what are the deficits for the ghost students so far? And then have you detected them and stuff like that? Thanks.
Yeah, thanks, Honorable Law. So in relation to ghost students, right? When a student is verified by NSFAS, their ID number is confirmed. The ID number that they'll input to our system is confirmed against Home Affairs. The ID numbers of their parents is confirmed against Home Affairs. If they cite that they don't know their parents or they're living with foster care, they have to provide supporting documents to that effect. So we are quite reliant on Home Affairs in attributing that that is a citizen of the country that is applying for NSFAS. Yeah. Secondly, is that when an institution registers a student, they equally have to confirm the ID number and link that student to a student number. When we run the matching process with institutions, the ID number of the student confirmed for funding and the ID number of the student confirmed at the institution must match one another. Now, having gone through that process, you would have to defraud a lot of systems or processes to become a GO student, right? You would have to override the NSFAS system, but equally you would have to override the institution of higher learning system here. Yeah? And you'd somehow have to get those two systems to match one another, having overridden them both. I'm not saying it's beyond the realms of possibility, but there are significant controls in place to prevent that from happening here. Equally, there are similar controls over when a student can input their banking details and how they can amend their banking details in nature. Yeah. So, in my view, there are quite a number of controls which are in place, but over to that, we do additional tests. So, for example, our internal audit department will go and select a sample of students. They will ask them to present themselves at financial aid so we can test whether the students that we are funding actually exist. They will be asked to come with a proof of their ID, so we can also check that the ID numbers on the system match the IDs on the ID document here. What the Auditor General is raising, which I have quite a bit of concern about, is that we are making incorrect funding decisions. So the Auditor General takes our funding decision, it runs it against databases like eNatus, UIF, CIPC, and it says the students that you are funding don't meet the household income criteria of 350,000. I haven't had enough time to interrogate what the Auditor General is saying. We've put a task team together to investigate all of these assessments that are being done. I find it quite strange that somebody whose income is less than 350,000, the Auditor General says they are a family that owns 2 cars. But by the way, it doesn't matter. You could own 2 cars and still have household income which is less than 3. But I'm saying it's a concern that's been flagged, and we will continue to investigate.
You have never encountered any ghost students in the system? That's what I wanted to check. I agree with the systems that are in place to mitigate. Have you never encountered any ghost student that creates a deficit or a systems collapse as part of your systematic problems? That's what I wanted to check.
I can't say to you that a ghost student has been presented as evidence to me, Chair. It's continuously under investigation, but I've not received a report to that effect.
Okay, thanks. Thanks for that. I want to move, and I want to move to another question that says that there were allegations of systematic racism and bullying within NSFAS in governance structures. Slide 10 and slide 12 of your presentation. How true is this? What can you say as a CEO?
Chair, I'm not aware of any bullying or racism that would have ever occurred in my presence here.
You don't have any toxic environment in NSFAS?
Chair, I can't allude to any toxic environment that has been present since I joined NSFAS.
I'm asking this because there were a number of articles and there were a number of allegations, and hence I could have asked the minister on the letter of the former chair, because of allegations would have seen that the former chair left unhappy, maybe, I'm not sure. That's why I wanted to clarify Parliament so that we can clarify that. Thanks.
Yeah, thanks, Honorable Whip. So, unfortunately, the issue of the media is a little bit tricky because the resignation letter of the chair including her letter to the minister, somehow found its way into the media. The media presented questions, I think it was the Monday or the Tuesday after the chairperson had departed, asking me specifically to respond to allegations that had been made against me. As you know, if you don't respond to the media, they will put a nice piece at the end of the article to say, we repeatedly requested comment from NSFAS and there was a failure to respond. So once you get questions, that is your right of reply in terms of the press code. As the delegated representative of the board, I drafted responses to indicate our view as to the matters of the former chair and duly responded to the media. I'd be happy to share with the committee chair the questions. It was from 2 publications. Business Day would have sent us questions as well as News 24. I'd be happy to share with the committee secretariat the questions we received as well as the responses that we provided.
Honorable Khakha.
Just on this point, Dr. Stander, the CEO says he knows nothing about toxic culture of intimidation and victimization and all the things that you have identified. Have you, during your tenure as the chairperson of the board of NSFAS, ever brought it to this acting CEO's attention that what you have registered now is your observation during your tenure? Had you done any of that? Dr. Stander, are you there?
Yes, I'm here.
Yes, so do you have a response? Or would you like me to repeat my question?
No, I did raise it. Maybe you didn't understand it in that way when it was raised, but I did raise it.
When you raised it, what was his response?
I can't recall word for word what the response would have been.
Dr. Stander,
Yes, sir.
I also came across allegations that you have once written to outer to either attack the CEO or the minister. How true is that?
Written to Alta to attack
The minister or the CEO?
No, I've never written to Alta to do any of that. I visited Alta with the former minister and the DG. We had a meeting together, all of us. I also had a meeting with the Alta with the acting CEO after the meeting with the DG and the former minister, with permission from the former minister. That is my engagement with Alta. Thank you.
Okay, Dr. Stander, just for the record, you are saying you had a meeting with the outer yourself, the DG, and the former minister.
Yes, sir.
When was this?
I can't, just when I started a chair, it was still at the University of Pretoria.
You're not clear there. You're saying just around?
Just when I was appointed,
Or at
just
the
after I
beginning
met
of the
with the
year?
SIU. Yes, yeah. And it was still at the University of Pretoria.
Okay, no, it's fine. Honorable Law.
Or you never had a meeting while you were at NSFAS? Okay.
No, I was at NSFAS, but the meeting was held at the University of Pretoria.
Oh, you don't mind telling us what was in the agenda to discuss? Maybe in a summary?
I think in general what was discussed was the well, I would put it at the accommodation related issues. And but I don't know, for the lack of a better word, what I would call almost a I don't know, a capture of accommodation, or the I don't know how accommodation was put together previously into a money making machine. I don't know how to put it. But I can tell you that engagement with ALTA and the previous engagement with the SIU has made me fear for my life as I'm sitting here.
Wait, Chair, Doctor, I wish you could have maybe spoke out of the mic so we can hear you properly, because I would have liked you to repeat what you have submitted, because I would have wanted to know what was on the agenda without so that I can do my follow-ups as you go. So I'm not sure, you are not a bit clear. Don't you mind repeating yourself?
I think can you hear me now?
Yes.
The agenda was mostly around ALTA's investigations that they have been doing before our time on NSFAS, and the operational matters and inefficiencies and accommodation issues and accreditation. A lot of what the portfolio committee has raised, accommodation not being up to standard, that type of thing. I can't hear. No, I can't hear.
Okay, no, thanks. My question was based on the fact that after having this meeting of accommodation, have you ever raised it in the board, or the board members, or with the CEO?
Yes, I had after this meeting with AUTA, there was a second meeting with AUTA, so that the acting CEO, where the acting CEO was also present, so that he would also know what is going on. It was the similar issues was raised by the SIU, and the current chairperson or acting chairperson was in that meeting with the SIU, as well as Advocate Kuta, that's also there today.
Dr. Standard, thank you very much. My time is up. I appreciate that you could have given that information. One will follow up to a letter, and then to check to those that you could have mentioned on the discussions and the agenda. Thank you very much, Chair, for the opportunity. So that thanks.
Yeah, no, hold on. Susan, no, I'll give you just a few seconds. Advocate Kuta, what is your understanding of the King 4 code? King 4.
Is to ensure that corporate governance, to ensure that you comply with corporate governance issues.
And it is your considered view that it shows good corporate governance when somebody changes their responses depending on the meeting setting, or depending on where they are. Do you think that shows good corporate governance?
Chair, your question is tricky because I don't have the context.
No, we're just in principle. We're going to go to context at a later
Oh,
stage.
okay.
We're still busy with principles. Now, the principle, do you think it's good corporate governance for somebody? Or would that person show good corporate governance if their responses depends on where they are?
I would say it does not.
I really appreciate. I want to draw a picture for you, Minister, quickly. I think I want to share the sentiments first of colleagues who believe that our biggest problem in the sector is with the whole department. It's with the Department of Higher Education. We have big problems. On the 3rd of September, we had a meeting in Caledon. The department, unprovoked, gave us a presentation on infrastructure because Parliament has identified our committee as one of those that must respond or do oversight on infrastructure because of the amount of money that we put as government on infrastructure. So we write to the department as a department, give us a report on infrastructure. Unprovoked, the Director General makes a presentation. In the presentation, the Director General says, we have not spent this money on student accommodation for Majoba TVET College and Hertzbanda TVET College because we were awaiting ministerial approval. We sit here in this meeting just after the meeting of the 19th. I think it was on the 24th of October, if I'm not mistaken. Or something, 22. I think 22nd of October, or yeah, it was not the 29th, 22nd of October. No, around September, I think 24 September. Honorable Zondo asks, it was, you were present in the meeting, asks this question. Then the DG, the acting DG was acting DG that day. Then he says, no, planning can answer it better. DDG Gasa gives a different answer. And he says, no, it was not a ministerial delay. But that was because the minister is in the meeting. And we believe that the department gives us answers depending on who's in the meeting. The DG on the 14th of May, 2025, members asks construction center, why have you not implemented the Tuja report where we have spent 18.9 million of state resources that we don't have? The question was asked to construction center, the DG responds, unprovoked. He says, we have implemented, we're on high speed. We're implementing that. Hey, we are very far. Hey, we're here in this vein, yes. 14 May. Yes. And I asked him, why are you answering why? Just like I was asking the Mabuse. Why are you answering why you have, what you are not asked? On the 19th of September, the last time the TG attended our meeting, he says to us, we have not implemented the Duja report because it was never given to us. I've never seen it. He says, I've never seen it. Yeah, then all of a sudden he says, oh, he wanted to
Say it was contested and it was
Yeah.
tampered with, we can't implement.
Yeah. So, this person, now that we know now, you know what we've known all along. Because this question of the regional manager of KZN, we have written, I don't know how many questions to the ministry, to your predecessor and yourself. And now you know the facts. And in the letter that you wrote to us, you had indicated that this Director General has written to you twice. Well, I'm just making examples of two. But there are many examples I can make. On the 31st of May, he was busy whispering to the former minister. Every time the former minister must answer, he whispers. And then he said he doesn't know anything. In that meeting, he commented, I think it was Honorable Kakao asked him a question. Okay, Buti, because you are whispering, tell us what happened. Or the process was clean. You see, I've been a DG for some time. This is the cleanest process I've ever seen of this accounting authorities. This was 31 May 2025. On the 21st, when you took oath as a minister, on that day, no, on the 22nd, we had a meeting of the committee. Unprovoked, he said, before we close check, can I just say something? I allow him. He says, I'm going to allow you, don't know. He says, Chair, I'm sure I'm speaking, and I'm quoting him verbatim, because I said there and I looked at him and I said, Angiaz Lindole. He said, I'm sure I'm speaking on behalf of all the DGs, that processes like this, if they're given to us, we'll run them smoothly. The problem is when we're not given space to work. In essence, a day after former minister was removed, he no longer knew. He was no longer, was excluded from this thing. Now, he has written to you twice. The only reason that we kept on asking you is because this memo, we've had it for some time. That I know in one of the answers he gave you, says the DG does not have delegation to appoint or transfer officials on level 14. This is one of his responses to you. But he does not tell you that it is him who wrote a memo misleading the minister that this fellow, Ngubane, is in the employ of basic education. It's him who wrote it. And said to the minister, this person is in the employ. When this person had resigned, we told him that's not, what you have said to us is not true. He said, no, it was a transfer in our meeting. Now, one member was asking you, I think it was Honorable Msaza, that what is the minister going to do in restoring, because haina double up, in restoring credibility in the department. You have a director general who, by the way, has cost the state. This person was supposed to have applied to be a regional manager. The state was defrauded. Yeah, the state was defrauded from this 2020. This person, even if you go through this document, you'll see, they sign it, I think in February, they say the transfer will take effect from October of the previous year. Moshapaga back pay. A person who had resigned in August was at home, having resigned with immediate effect, gave solid reasons, we agree, why he wanted to resign. But he resigned. Now this person, in fact, it does not even end there. If you look there, he was even given a pay raise. Now, from a corporate governance point of view, Minister, are you willing to agree that this one needs, we need to restore credibility, we need to restore, maybe let me not say credibility, we need to restore trust, confidence on our people that once a wrong thing is found, your ministry is willing to correct it, Minister.
Thank you, Chairperson. I've just asked Acting DG Zungu to just write me the chronology in terms of time. So when you see him whispering or sending something, please do not crucify him. I've asked him for that chronology of events. When we had the debate on the budget vote, Honorable Msezana mentioned this case as part of the debate. And at the time, as part of the debate, I indicated in my response that we do not act on the basis of allegations without investigations. I mean, without evidence, and so on and so forth. And true to form, as soon as I took oath of office, Honorable Msezana quickly reminded me by writing me a letter, specifically, informing me of the details, because at the time when I received the letter, all I was aware of was the statement Honorable Msezana had made in Parliament. And so he sent me a letter asking for information in this regard. I wrote to him back. I think there were several issues that he was asking me about, but I can remember specifically about this issue, indicating that I've put it to the DG to get a response. And subsequent to that, Honorable Msezana asked me, what have I done? I told him that I have received a response from the DG, which I'm not happy about, and I have asked for more information. And even with the information, the more information that I had asked for, are still not happy. About a day or two ago, I don't think that that's necessary actually. So about a day or two ago, I think on Monday, the information which I am made to believe has now been sent to the Secretariat today was brought to my attention. Now, this is information which
Chair, sorry, Chair. Actually, the minister is speaking on the order of events. He only spoke about the first response from the DG, not the second one, which he has alerted that it was on the 30th of
Now
October.
he's responding to my question about the good corporate governance.
Okay.
Yes.
Okay, so I think that the point is that that information which we've now sent to, which have consistently, indicated to the honourable members that I can only act on the basis of information. So that information we've sent to the Secretariat, and that's the information which I'm going to be applying my mind in terms of what action is to be taken. I must emphasize, since Chairperson referred to King 4, that just like any other matter, this matter will be dealt with legally and rationally, and so on and so forth. If I think if I could leave it, on that, just to give the committee the satisfaction that I am attending to this matter. I do not think that it will help the matter if I ventilate the details thereof here in Parliament. If I can beg your indulgence, thank you.
No, thank you, Minister. Well, the issue was just to comment, to give confidence that the matter is being attended to. We don't sweep things under the carpet. That is the point I wanted. We do have the chronology. You also have them, Ms. Kruger gave them to you. From 2022, this is what happened until the person, I think, even resigned. So I was going to say, when you get into the issue of chronology, first page of that report speaks about those things. Advocate Kuda, earlier on I asked TDG Fuchani, what is a legal meaning, when she was talking to us about the current council of Northern Cape being in charge of, or also taking care of, other 8 councils. And it says the terms of reference there, or the contract they have with them, is that they are appointed until end of February or until their councils are appointed. What is your understanding of that statement?
Chair, I do not want to mislead you or mislead the committee. I'll need to go and check what the SETA Act says, and I do not have a copy right now with me.
Okay. I'm not asking specifically about, I'm just making an example. Not specifically about what it's, but if a contract says, Deboho, like me as a member of parliament, deployed by the ANC, our contract says I'm appointed until the next elections, or if the ANC removes me. What does that, what is your understanding of that statement? Does it mean that if the ANC doesn't remove me and 2029 elections come, I can still continue to 2030, 31, 32, and all of that? Does it mean that thing? It's not a trick question. I'm just trying to understand. I see you think we're trying to trick you. We're not. We're just asking a legal understanding. I think it's a very simple concept.
Yes, Chair, you can say it is simple because you do have the context of your question. But in my view, any contract would be allowed to run in terms of what is in the contract. If the contract says, come 2029, you should be out, I don't see why you should not be out when the contract says so. However, if your understanding of the contract is different from the person you had a contract with, you might find that there is now a dispute that has been, a dispute that has been declared. That is why I'm saying, Chair, it depends on the understanding between the parties who are parties to that contract. Thank you, Chair.
So when people draft contracts, you are a lawyer, you draft contracts all the time. What would be the reason why there must be a date, a specific date?
That specific date, Chair, would be the date that would say this is the end of the contract, it's expiring, or depending whether there is a provision for it to be extended.
Yeah, if there's no provision, what I've just said is, Tebogo, your contract ends May 2029, or if your party removes you. What does that mean? Does it mean I can come tomorrow and say, I understood this thing to be saying, I can go beyond 2029 May?
Because, Chair, you have now used "or" in your example. And in that case, if your party does not remove you, it would be correct for you to continue with coming to your job, if it's a job. But if the party uses the second part of the sentence that we just made an example of, it would have removed you and it would be the end of the contract.
Just to understand you are saying to me, that statement, if my party doesn't remove me and 2029 arrives, I must come back to Parliament even when that party does not have seats in Parliament.
That's a different scenario now.
No,
Because
Advocate, you see, that's why I said the problem is you want to complicate. You responded correctly, but you decided you thought I'm trying to trick you. Well, this thing is very simple. It's by the way, I've given this thing to about 12 lawyers, 12 attorneys, 2 of them senior counsels, all of them, they're giving me. So I'm worried that now in the department, because this thing is simple, that end date is there for a reason. You are an attorney, you should know. You know, it's there for a reason. And I've asked you, why do you have to get an end date? Because it says, this is where it ends. Tebogo, you are deployed on a fixed term basis from 2024 till 2029. Or the or part says, if anything happens in between, we can remove you. But it does not mean that or does not all of a sudden says you can go beyond 2029. And you know that's what it says. It's a fixed term contract. It gives you start date and end date. And then says in between, if you don't perform, if you are declared something and something, we can remove you. That's what but it's okay. We won't win because you thought it's a trick question. I'm going to give just one. Those of you want one follow-up in 1 minute. So even if you don't finish the minute, it's one follow-up. Honorable Msazan.
No, thanks, Chair. Mine was the fact that I was not satisfied by the response of the minister in and around the consultation process. The minister did not give us the consultation process, how it was done. You said however it was done, you did it. I was not satisfied. And when I looked at the agenda of the consultation, it appeared that in that agenda item of on administration, Mvalo or Ngubane Mabuza would have dealt with that item in the NSA. The same Mvalo that would have, after facilitating that discussion, then ended up being the administrator again, so would have benefited from whatever role he played in adjudicating or presenting that particular item. So I was not satisfied at all with the response of the minister. I still wish that the minister can finish the portfolio committee on what consultation process took place with the NSA. Thanks, Chair.
Okay, thank you, Chairperson. I think we can send you the details. I think in one of the requests that the committee had made was, if I'm not mistaken, specifically in terms of the consultation with the NSA and how it was done. And I think we can give you some more information on that, over and above what I've said in the committee. Also, I'm not sure what's the benefit to Mr. Mvalo is, but I think it's something that you'll probably explain. Him benefiting from the process, what does that mean?
Chair, so the item on administrators there at the NSA consultation meeting, which took place in your absence, the item was dealt by, it says Mabuza Ngubane / Mvalo or Zugile Mvalo. So either of the two would have facilitated that process. So I'm saying if Mvalo adjudicated or presented that particular item, then after presenting the item, it gets passed or you get the recommendation to put the SETAs under administration. And he so again happens to be the person that then benefits to become the administrator. So he would have participated in giving you the recommendation as part of the collective of NSA, then later benefits again to be the administrator of the same process that he would have adjudicated or would have participated in. So in essence, I'm saying he was conflicted and he benefited as such. So it wasn't so by in his a recommendation or whatever process that would, whatever participation he would have had.
Well, I don't know. I mean, unless if you suggest that he knew that he was going to be the administrator at the LG SETA, then that becomes a completely different ball game. But also, I don't know how is it a benefit. Zukile Mvalo is DDG skills, so him being an administrator at a SETA, I don't know how that constitute a benefit. Yeah, I think that's what confuses me. Okay, all right, thank you.
A few things, Minister. One, I want you to please
We did say one thing.
Yes, I'm gonna. I have 1 minute to make my follow-up.
One point. Oh.
You said 1 minute.
Yeah, I said
So
if you ask one point and it's still less than a minute, that's what I said. You don't have to take the whole point, the whole minute.
No,
The follow-up, no, the follow-up is on one point.
No, but like you
Honorable
giving me a minute.
Ngubane?
Can I decide what I do with
Yeah,
the minute?
it's like the contract, whichever comes first. Honorable Ngubane, she wants to think which one she's going to prioritize.
I think, Chair, mine, it was again on Dr. Is Dr. Gone online? I don't know, that USB that has been given to the SIU, did the SIU ask for that? I think, Minister, that the USB, that the evidence that you got, will it assist in terms of SIU investigation or what the USB pertains to in a nutshell that you were given. And my intriguing was to say, why was it submitted to the SIU? Did the SIU requested for it, or if you can assist on that, Minister?
Yeah, the minister can't know that question. The minister said he has not even seen it. He knows that it was delivered to his office on Monday or something. I think Dr. Standard explained that in a quest to save NSFAS, he has submitted this information both to the minister and SIU. I think it's
Thoroughly.
it's an effort to assist. Honorable Lonzi. Okay.
Yeah,
Okay.
okay. Nna ke a tseba ke batla
batla
hore ka
NSA.
1 minute. Minister,
O batla NSA.
according to man, wa bona he. How sharp. Minister, according to Section 16B of the Public Service Act, the issue of Ndate Mabusela's investigation on irregular expenditure was moved from investigation by the fund to the department. Where are we with that investigation?
I don't have any documentation in front of me that speaks to Mr. Mabusela's investigation or anything of the sort. I've learned of this in the media, through media questions. I've asked Mr. Mabusela himself to give me a report. And as far as I'm concerned, I think information pertaining to all of these things, is somewhere in the department. It's not yet on my desk. And I think as soon as I have that, I have sight of that, I've asked for all of that information. As soon as I have sight of that, then I'll determine the way of action.
I'm asking, Minister, because this is something that you should have known as a thing. So you knew that Dr. Mabusela left the National Skills Fund under the reasons why he left. And when you appointed him, I'm assuming that this is part of what you were supposed to consider. So it's not a case of you appoint him as acting DDG skills, and then after you go find somewhere in the department where you don't know, but perhaps the Director General and Natema Butsela would know where that is, if you follow me. Because I think for me that is reckless to make the appointment without having ascertained yourself what the status of Natema Butsela's investigation for 1.3 million rands worth of irregular expenditure is.
Well, I maintain, Honourable Member, that I wasn't aware of the investigation. I became aware of the investigations when my office received media queries, and I'm awaiting full details in relation to this particular case. Thank you.
Honorable Lonzi.
I didn't want the board member of NSA to travel all the way to Cape Town and not even say one word, Chair. That would be wasteful expenditure. So I've just got one question for you, NSA. On the 7th of August, did you have a consultation meeting with the minister where during the consultation, the business of the day was discussion of the investigation that was initiated by National Treasury following the allegations from an anonymous whistleblower consistent with the principles of accountability, ethical governance in the public sector? So I'll repeat it again, and I'll make it even shorter. On the 7th of August, 2025, did you have a consultation meeting with the minister as the National Skills Authority where the business of the day was discussion of the investigation that was initiated by the National Treasury.
No, thanks. Good evening, Chair. I will not get into the semantics in terms of the interpretation of the consultative process. But then what I would respond to will be in terms of the notice and the agenda for the meeting of the 7th, as you are alluding, which is...
Sorry, I have to interrupt, Chair.
Okay.
I'll try again, Tata. On the 7th of August, 2025, did you have a consultation meeting with the minister? And by you, I mean the National Skills Authority, where during the consultation on the 7th of August, the business of the day was the discussion of the investigation that was initiated by the National Treasury. I don't want semantics. I just want to know, on the 7th of August, 2025, did you, as the National Skills Authority, have a consultation meeting with the minister where the business of the consultation was the investigation which was initiated by National Treasury? It's a simple question.
No, I understand that it's a simple question, though, okay, fine. We had a meeting on the 7th of October where we discussed...
I'll interject again, Chair. I'm not asking if you had a meeting. I'm asking you, on the 7th of August, 2025, and I repeat, did you, the National Skills Authority, have a consultation meeting with the minister?
Please answer the
It's
question.
a very simple question.
It's okay, it's okay. Please answer the question.
Yeah, no, it's good. Chair, we didn't have a meeting with the minister on that day. However, we were supposed...
Thank you, Chair. That's my only question. I'm not interested in other information.
The point, you see, okay.
My 1 minute should be finished now.
The question was,
no,
on
Chair.
the 7th of August, was
Yes.
the question is not, did the minister consult with the NSA? That's not the question. The question is on the 7th of August. So you have answered the question of on the 7th of August.
Okay, can I ask something?
No.
And direct it to you, Chair,
Ask
through your
me.
indulgence.
Yeah.
Maybe through experience is that when meetings are convened, there will be a notice and an agenda.
Yes.
And when the meeting begins, you then are expected, according to the adopted agenda, that there shall be an item.
Yes.
And when that item is about to unfold,
Yeah.
then you receive a message or a notice that there's an apology because of certain, because of an emergency and so on.
Yes.
Having adopted the agenda.
Yes.
So that is why I was trying to explain. I'm not coming back to that fact. I'm just to put an indulgence on organizational processes that have to be appreciated. Thanks.
Yeah, so it's not also assisting us because just because we have adopted a 3-month program, it does not mean we have had a meeting with the NSA. So let's say we're going to meet with you in February as the NSA. We have not met with you, but we have adopted our program. So it does not help us in getting to what the questions are. So the question is, on this particular day, in which we have answered, and that the Mabuse.
Thanks very much, Chair. Yeah, I was really hoping that you'll give me this chance, the right to respond. And I've done so, even in the article that the honorable member is quoting. But for starters, that article, Chair, if one,
What are you responding to?
Honorable Kakao,
No, Honorable Kakao asked the minister.
Arulukise mona
about-
chair. Askis. Arulukise mona. Sfansaka sa kakao.
No, I'll fix it. It's Honorable Kakao. And she was asking the minister about when he appointed you to act, if he was aware of the allegations. So there's no need for you to respond, because the minister did respond.
it's fine, Chair. I'll take the direction of the minister. She has given that direction. It's a propaganda on steroids.
Okay. Ukana tima mic, ndati mabusela. Yabona ro. The minister responded. Wabo. Yeah. So I want to thank you, members. What is the you are not asking anything?
No, it's just our people here, we are winning a by-election, third councillor in Ilembe region, so we must report when our people are saying we must report. MK Party is winning the third councillor in one region. So it's just...
Okay. Hey, now we are going to create a problem.
Mabebuya khamba thina, Chair. Mabebuya khamba thina.
Congratulations,
So
congratulations,
Okay.
congratulations. Thank you. Winning is nice, thank you.
I've also just received an email and inviting me to the Ukrainian embassy. So, no. I'll speak to Honorable Msazana to tell me which flight to take when we go there. Thank you very much, Minister. Acting DG, acting DDG, NSFAS, acting CEO, NSA. Dawetu, I will must refer to you as a former board member. I'm joking. Board members of of NSFAS. No, it's almost. Yeah, it's not yet dissolved. Almost. Advocate Kuta, thanks. The team from the department, Mampi, our colleagues from Parliament, the members, thank you very much. Honorable Law, what is the point now?
Chair, thanks. Can I propose that before we close, you take Advocate Kuntat for lunch before next year, 2026? Thanks.
Seconded.
Do a variation in the department's budget to make sure that.
Not to say these days. But yeah, thank you very much. We took longer than we thought, but we needed to ventilate on some of these things because leaving things hanging does not help anyone. Having said that, I want to thank you, members. Next week, Wednesday, we have our last meeting of the year. We're interacting with the NSF. And I think NSFAS on their annual report. It's very important that NSFAS gets to a point where they submit their annual report on time. Earlier on, we had a discussion when when Saus was saying this thing that NSFA's budget in real terms is going down. It's we don't understand it, but we had to come in and indicate that if you can't account for the monies that you are given, you then lose the voice of crying over other things. So NSFAS honestly must come right. It's an important institution to fail. It's an important institution that has produced about 6 million graduates who ordinarily would not have even seen the doors of learning and culture, let alone to graduate. But 6 million. It's a big, for us, that's a big deal. Many of us in this room will not have seen any university, let alone to graduate. So it's in our best interest, and those who come from spaces where we come from of poverty, that we must make sure that NSFAS succeeds. So we're going to guard it jealously. If there are people who have their own interest there at NSFAS, we're going to fight them properly. Because that thing is a national treasure that we must protect. Thank you very much, former chair of NSFAS. On the platform, we really appreciate you coming to share your side of the story. So, having said that, colleagues, good night. This meeting is now adjourned.
Chairperson.